Item 61, that day also I mentioned before this court. Actually, I am in bereavement. I have come back from my native for just for this case. Can it be taken up immediately after the motion?
No, what is the urgency?
Milord, he is behind the bars. Milord, he is a Muslim man.
But all are behind the bar in this.
No, Milord, the thing is that he is arrested in a bailable offence. Okay. And there is no materials, whatever the sections that shows. Milord, I satisfied on that count also. Lordship wanted to see the lower court's order why he was refused the bail. And that was not annexed at the time on the first day. I have filed an additional affidavit that is on record, Milord. It will not take much time, Milord. Actually, I prayed for two reasons that he is behind the bars. Even in this there is a bailable offence. Number one. Number two, my personal count, Milord.
Your personal ground.
My personal difficulties, Milord. Saddo ceremony of my Burma. He died just a few days ago. I have to attend that, and I come back for this case.
Okay.
Just after the motion matters.
Okay.
I'm Victor.
My Lord, in regard to item 25, my Lord, if your Lordship can accommodate me at 2 p.m.
At 2:30 we have fixed matters. 2 p.m. also we have 2 fixed matters.
Then let it come with the
Item number
25 minutes.
25.
Before 1, my Lord, if it is possible.
Okay. We may, okay, let us see.
My,
Otherwise, that
My lord, last 2 days, my lord, yesterday also my matter was at 2.
may I please
at 2 we will take 2 matters. One at 2:30.
May I please Lordship? Sir, item number 67, my Lord, I'm humbly paying for upgradation, my Lord. On last
No,
occasion,
how
also,
we
I
can
missed the bus, my Lord.
upgrade everything?
My Lord,
Then list will remain the same list.
my Lord. My Lord, if possible, my Lord, if it is not inconvenient, my Lord. So, because it was listed on
No,
previous
it is-
2 occasions,
it is
my Lord.
not possible
My Lord.
upgradation because all are behind the bars in this court. So let us see item number
67, my Lord.
is unlikely to reach.
It will not take much time, my Lord. Short matter.
Let us see.
No. 26.
No upgradation. Let us see in the second half.
Lordship, mine is high. It's 26, Lordship. At least as the last item. 26.
Last item, that means after
Lordship, let it come serially.
no, she is praying for last item.
Last item, Lordship.
That means after 61.
Because the 231 item is fixed already. So let it come serially. Serially, everybody.
Serial. Okay.
Or okay.
Appreciate Lordship. I'd like to mention for listing of the matter, Your Lordship, urgent matter criminal division petition, Your Lordship.
You have to mention before senior court. Same roster is taken up by senior court.
Now senior learned in the division batch, Your Lordship.
No, there are other senior courts. Court number 18 is there.
Lordship.
There are other courts taking up same rosters. You look into the roster.
Less than 5, it is 5 years. That is revision petition.
No, criminal revision, there are other senior courts taking up same rosters. The convention is you have to mention before the senior most court. If more than one courts are taking same roster, then senior most court.
Allow a listing, for the listing, Your Lordship, not posting, Your Lordship.
For listing, it is necessary to mention before the senior most court.
May it please your Lordship. Lordship, item number 62. My Lord, this matter may not be taken up today, my Lord.
60,
Personally,
item number
62 of the supplementary list.
okay.
Where the conducting counsel is having some personal difficulty.
Mr. What is your name? What is U Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the personal difficulty of the conducting counsel, Mr. Firoz Khan. Considering the submissions, the prayer is allowed. Let this matter be listed after Bihu vacation.
Item number?
62.
Lordship, item 21, Lordship. May come after Bihu.
Item 21,
Lordship,
heard Mr. S. Munir,
21.
learned counsel for the petitioner, who prays for an adjournment on the ground of,
Some law points. You
okay, on the ground that he is to look into some law points in that case. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after Bihu vacation.
Lordship, much obliged.
May I please, Lordship? Item 13, Lordship. I file an additional affidavit, Lordship. Lordship, I may be allowed to it on record, Lordship.
Item 31,
1, 3, Lordship.
3-1. 1-3.
1, 3, 13.
additional affidavit.
Affidavit.
Okay.
Take to May please, your lordship, item number 39, lordship. Pass over for day, lordship.
On request of learned,
CD not received, Lordship. After
Interim,
Bihu,
interim is there, lordship.
learned
39.
counsel for the petition, Mr. N. Ahmed, learned counsel for the petitioner, prays for an adjournment. On the other hand, Ms. A. Begum, learned additional public prosecutor, submits that the case diary has not arrived and prays for another date for producing the same. The prayer is allowed. Let this matter be listed on 30th of April. The interim order shall continue till next day.
Deeply obliged.
Lordship, I would like to mention item number 18 on behalf of senior counsel, fee junior Lordship. Lordship, that fee junior due to her health condition, she could not able to come. Doctor has directed her to take a bed rest for at least a week's, Lordship. Therefore, she
Please,
walked all
what's
the
your
way
name?
from the Itanagar.
Okay, 1-8.
That's why, Lordship.
1-8.
Your name?
Pardon, Lordship.
What is
1-8. The Lordship matter may
1-8.
kindly fixed on 17th of May, Lordship. And it
What is your name?
LG.
Heard Miss. So, naam likhe do.
L-
Learned counsel
L-
for the petitioner, who submits that due to personal difficulty of the conducting counsel, T. Genie, an adjournment is prayed for. Stop. Considering the submissions, the prayer is allowed. Let this matter be listed on
17th of May.
17th of May.
Lordship, interim may
The
continue.
interim order shall continue till next day.
Obliged.
May please, your lordship, item number 47, 48, kindly list them at 230, lordship.
Item
47, 48.
at 230. 47, 48.
230, we have already fixed.
Already
matter.
item fixed.
Then, if you can, lordship, then 2.
2 also most of the item are fixed.
No, it will be called serially.
Serially.
Okay, lordship.
May please. No, item number 33, my lord, city probably not there, my lord. I mean, in time, my lord.
33. CD not received, Lordship. CD after Bihu.
Heard Mr. S. Thakur, also heard Miss A. Begum, learned additional public prosecutor, who submits that case diary has not arrived and prays for another date for producing the same. The prayer is allowed. Let this matter be listed after Bihu vacation. The interim order shall continue till next day.
Obliged.
May it please, your lordship. One item, my lord. Item number 44, my lord. But he was convicted for a period of 10 years, my lord. I'm already behind the bar for, my lord, more than 5 years, my lord. I think I had a good case, my lord. If the lordship permits me as the last item, my lord. Today, my lord. For me, my lord. And they have also filed the objection also.
Let us see whether,
I'll try.
Try.
Chance.
Let him try.
let us see whether we reach or not.
After 3:30.
May I please, your lordship? I beg to mention a listing a bail application, lordship.
Matter relates to
May it relates to NDPS, lordship.
other courts, senior court.
Only item number 1. May it please, my lord. It's a 439 application, my lord. Allegation against me, my lord, 379, 420, and 34, my lord. But FIR is page 11.
We'll bring the CD lordship behind 17-3 lordship.
Heard this.
My lord, one submission, my lord. It's a offense is still, my lord, for 7 years, my lord. There is no 41A notice was served upon me, my lord.
Lordship,
on
let it fix on
17
Monday lordship then.
Yes, my lord.
Monday lordship.
Or case diary.
Case diary, we will inquire also lordship whether 41 is served or not.
Okay. Heard Mr.
M. Kolita.
M. Kolita, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 439 of this Code of Criminal Procedure, 1973, has been filed by the petitioners Sahil Ahmed and Mohammad Nuruddin Khan, who were arrested on 17/3/2024 in connection with Patshala Police case number 28/2024. Learned counsel for the petitioner has submitted that though the offense alleged against the petitioner in this case have punishments less than 7 years. However, no notice under section 41A of the Code of Criminal Procedure, 1973, has been issued to the petitioners prior to their arrest in violation of the mandate of law. Considering the submissions made by learned counsel for the petitioner, learned additional public prosecutor sought for 2 days' time so that she can take instructions from the investigating officer of Patshala PS case number 28/2024 as to whether notice under section 41A was issued to the present petitioners or not. The prayer is allowed. Let this matter be listed again on 8th of April.
CD and CD also lordship have said
On Monday.
on Monday.
Okay. Let the case diary be also called for. Fix this case on, let it be on Tuesday,
Lordship.
on 9th of.
May it please the lordship. It's a 439 application, my lord. My lord, I jumped the bail, my lord. My lord, during trial, my lord, I was absent from since, my lord, 2018. Lordship, may turn to page 27, my lord. The order passed by the court below. It's an order dated 11/3/24, my lord. Second paragraph, the petitioner submits the accused is her son and he was arrested on 22/1/24. The accused is told so and so, my lord, and he could not remain present on earlier dates owing to her illness. The petitioner further submits that she is suffering from cardiovascular disease and the presence of the accused is highly essential as she is being looked by him. In the event of grant of bail, the accused shall appear regularly before the court and face trial. My lord, next paragraph, my lord. From the case record, it implies that the accused since 2018 remained absent and the medical document shows that the petitioner underwent treatment on 1/7/21 and the accused underwent treatment on 28/4/22. The long absence of the accused for about 6 years has resulted in delay with proceeding of the trial in the present case. That's the ground, my lord. I could not be present, my lord, admittedly, my lord. Now, in this case, my lord, I was arrested on 22/1/24, my lord. I will appear fully cooperate with the
What is the stage of
evidence.
Lordship for charge, lordship. Framing of charge.
Framing of charge.
Production and framing of charge.
how many accused are there?
My lord, as total, my lord, page 21. 6.
Now, if you are allowed to go on bail, you will again jump bail.
My lord, this time, my lord, strong condition, my lord.
Yes,
stringent condition.
heard Mr. N.J.
6
Datta.
years he is absent, Lordship.
Yes.
N.J. Datta, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Raju Rajbanshi, who has been detained behind the bars since
2018.
22/1/2024 in connection with GR case number 806/2017 pending before the Court of Learned Subdivisional Judicial Magistrate, Lakhimpur, North Lakhimpur. It is submitted by learned counsel for the petitioner that earlier the petitioner was granted bail, was on bail. However, he could not appear before the trial court. Why you could not appear?
My lord, my mother was ill. Sir,
On the ground of illness of his mother. And
This will be the last chance, Lordship.
as she was suffering from cardiovascular disease.
illness of her mother, illness of his mother. And when were you arrested?
At present, my lord, no, earlier, my lord,
Present
presently, my lord, on 22/01/24.
on the strength of non-bailable warrant of. Thereafter, the trial court issued non-bailable warrant of arrest. And on the strength of non-bailable warrant of arrest, the petitioner was arrested on 22/1/2024. On 11/3/2024, the petitioner had moved an application for bail before the trial court. However, same was rejected owing to his past conduct and considering the fact that sufficient delay was caused due to the absence of the present petitioner. Learned counsel for the petitioner has submitted that now that the petitioner could not attend the court on earlier occasion owing to the ailment of his mother, and he is behind the bars, and now he is behind the bars since 22/1/2024, and charges are yet to be framed. It is submitted by learned counsel for the petitioner that petitioner would cooperate in the trial, and as he is the sole bread earner of the family, his detention has caused immense hardship to his family members. Considering now what is your submission?
My objection may be recorded, Lordship.
Learned additional public prosecutor objected to the said prayer. I have considered the submissions made by learned counsel for both the sides and perused the materials on record. Though the conduct of the present petitioner is not in past is not encouraging, however, considering the fact that he has been detained behind the bars since 22/1/2024 and charges are yet to be framed, and also considering the submissions made by learned counsel for the petitioner that the petitioner is the sole bread earner of the family and he is ready to cooperate in his trial. comma, the the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned subdivisional judicial magistrate, Lakhimpur, North Lakhimpur, with following conditions: that he shall cooperate in his trial and shall regularly appear before the trial court as and when so required. Any default by him this time would be a good ground for cancellation of bail granted to him. With above observation, this bail application is disposed of.
I'm deeply obliged.
Three, two.
May it please his lordship, my lord, it's a 439 application, my lord. The lordship may directly come to, my lord, the forwarding report, my lord. At page 14, my lord, 14, my lord.
Since when you are,
Since, my lord, 7/3/2024, my lord, almost a month, my lord. And the materials have been recovered, my lord, that your lordship will find from the seizure list, the next page, my lord. Only, my lord,
Will the CD be there, lordship? We will bring on 10, lordship.
6 aluminum cables and 20 pieces of U-bolt, my lord.
case diary would be required.
6, 10,
Ah.
10.
Heard Mr. N.J. Dr. Leonard, counsel for the
Definitely.
petitioner, also heard Ms.
Not
A. Baker,
tomorrow,
Leonard,
public
additional
police,
public
Sunday,
prosecutor. Call for the case diary.
তাহলে
Fixing
পিছত লওক।
10.
10,
I'm obliged.
10-4.
10 for lordship.
Okay.
Yeah, lordship. 439 application, my lord. Regarding theft of a vehicle, my lord, CD may be called from, my lord, 15 days behind the bar.
Heard Mr.
So 15 days, lordship, so after Bihu, lordship.
R. R.
Huh?
R.
Immediate নহব,
Supriya,
আপনি
Leonard,
ice man
counsel
লওক,
for,
তেতিয়া আহিব।
heard Mr. A. Khonikor, Leonard, counsel for the petitioner. Also heard Ms. A. Begum, Leonard, additional public prosecutor. Call for the case diary,
22-4.
fixing 22-4 for case diary.
Deep lordship.
Lordship, matter may be kind of at 2.
Not two, we will call as per our convenience.
Then for time. Senior is becoming.
Lordship, let it be a revision, lordship. The date may be fixed, lordship.
No, if it reaches, we will call, not at two, we'll call at as last
As-
item.
As time permits.
May I please, your lordship? Simple petition, my lord, we are paying for recalling of the warrants NBWA issue against the petitioner. This case is in the year 2019, and since 2021, non-bailable warrants were issued. And lordship, we may be directed to appear.
Oh, why you are not appearing?
We were actually not in Assam and we had no knowledge regarding.
Lordship, POXO 6 is there, so notice must be go, lordship.
Yes, yes.
Notice will go.
My lord, it's a 482 application for the quashing of the complaint, my lord. What happened, my lord, we are the two petitioners here. Apart from these two petitioners, the 6th person, we have basically filed a complaint before the RERA, my lord, initially, my lord. That we have not given the possession. From 2015 onwards, we have been not given the possession by the respondents, my lord. He was a builder, my lord, developer, my lord.
Okay,
So there's a sale deed, everything has been executed, but no possession has been given. So accordingly, my lord, we have filed a complaint before the RERA. Now lordship will find that complaint in 107, my lord.
Yes.
This is the basic complaint, my lord. Lordship will find 108. These are the person concerned. Apart from me and us, there are other person who is signatory to this complaint, my lord. Accordingly, notice has been issued to all of us before the RERA, my lord. I have annexed the notices also. Thereafter, my lord, page 109 onwards, my lord. This is the notice by RERA to all the person concerned as a complainant, my lord. 109. Thereafter, my lord, 110, my lord. This is the order of RERA, my lord. This is important, my lord. Page number 110, my lord. It is on 19th of July, lordship kindly mark, 20th July 2019, my lord. With reference to above, I am directed to refer to the complaint petition mentioned, the above secret and the document submitted by MS Akasdeep Builder. This is the Akasdeep Builder, the respondent, which have been thoroughly examined. It appears that the members the matter is sub judice is hereby informed that the builders, MS Akasdeep Builders, shall execute the registered sale deed with the purchaser of the flat Akasdeep as soon as the NOC is obtained from the office of the Deputy Commissioner Kamrup, and accordingly occupancy certificate is also provided to the purchaser of the flats.
It shows that they are participating.
So they have participated in the proceeding, my lord, the respondent.
Way back in 2009.
They have in way back in 2009, my lord, 19. Thereafter also, my lord, there are several orders. And then the final order of the RERA, page 120, my lordship can see. 120.
Yes.
Has your lordship got it, my 120.
Yes.
The complaint, the LOT, Devabruta so-and-so, and they filed the complaint under section 31 of the real estate so-and-so before the authority, asking inter alia the respondent, the Akasdeep Builders Limited, to be directed to execute the sale deed of the flats, which is they had already made payments and taken over the possession long back. After hearing the parties, it transpired that the sale deeds of the so-and-so. So accordingly, they have been directed to provide the possession. There are two directions in page 21. When this direction has been passed, my lord, thereafter what the respondent did, he filed a complaint, my lord, page 19, my lord, against us, my lord.
What is the complaint?
Page 19, my lord. Akasdeep Builders. What is now their allegation is that after so many years that these two petitioners who have forged the signature of the other complainant before the RERA, and we have filed that particular complaint.
Okay.
So the complaint which we have filed,
No, on what basis they are making this allegation?
only their basis, the one basis is that he has gone to some private agencies to verify the signature, and there is a private agency also that report has been, they have annexed that the some signature may not be the same. That is the allegation, and only that basis, my lord, the court has taken the cognizance under section 468, my lord.
Only 468.
Yes, my lord.
34 for community.
There are many other sections.
No, they have not taken. The court ultimately taken the cognizance under 468, my lord.
Regarding forgery of the signature.
Forgery of that document, because his claim is that the complaint filed by all the person, 6 person, is not the only 2 person is genuine, these 2 petitioner, rest of are forged by us, my lord. That is his complaint, my lord. And the basis of that complaint is that whereas my lordship has seen, all have participated in the RERA, all the complainants, to all of them has appeared before the RERA. After hearing in the order sheet, it has reflected that the parties has been heard from 2019 onwards. There is no complaint before the RERA by the respondent that these signature were forged. These other persons, the complainant before the RERA, they also appeared before the RERA.
Other letters also.
No, whether the other complainants appearing before the
Yes,
RERA.
the notice has been that the notice I have shown to you. The
Okay.
notice has been issued by him, and the last order also, it is all the person,
Where?
that is the order, my lord,
Page 120.
page 120. After hearing the parties, it transpires. Because to all the person, the notice has been issued, lordship, again, lordship can see the notice.
Where is that line after hearing the parties?
That is in the middle of the, my lord, the fourth line.
Okay. Okay, we are issuing notice.
Notice.
And it's same as.
The receiving of the notice.
No, my lord, the uncontroverted, and apart from, my lord, it does not create a 468 also.
Okay.
Because 468,
Heard Mr. A.M. Bora, learned counsel for the petitioner, assisted by Mr. D.K. Boido, learned additional learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioners Rajiv Bhattacharjee and Debabrata Basu Roy, praying for quashing of the criminal procedure, quashing of the order dated 30/9/2023, whereby cognizance of offense under section 468 of the Indian Penal Code has been taken against the present petitioner.
Mention kora nai no. I go to the chahi bole.
Where is the cognizance order?
my lord, cognizance order 106.
Against the present petitioners and only against two of you,
Only two of us.
against the present petitioners. Stop. Learned counsel for the petitioner has submitted the allegation against the present petitioner in the said complaint is mainly that they have forged the signatures of other complainants in a complaint which was filed before the officer in charge of, before the Real Estate Regulatory Authority, Guwahati, on 21/10/2016. Stop.
18.
21/10/2018. Stop. Learned senior counsel for the petitioner has submitted that the present petitioners, along with whose signature it
They are
is-
the other complainant who has not given the position. my lord.
No, what is their name? Whose
My lord,
signature?
the Swapna Majumdar, Bornali Dev, Anuradha Bhattacharjee, and Formita Kar, and Aparna Dr. Saha.
What was the last name? The present petitioners, along with 5 others, namely Bornali Dev, Swapna Majumdar, Anuradha Bhattacharjee, Paramita Kaur, Aparna Datta Saha, had filed the complaint before the Real Estate Regulatory Authority, alleging certain deviation by the respondent Akash Deep Towers Respondent number 2, Akashdeep Builders Private Limited. It is also submitted by learned counsel for the learned senior counsel for the petitioner that on receipt of the complaint filed by the present petitioner along with 5 others before the Real Estate Development Authority, Real Estate Regulatory Authority, notices were issued to all the petitioners as well as to the respondents on 25 June 2019. The notices were also issued to the other complainants, of whose signature it is alleged to have been forged by the present petitioners. It is also submitted by learned counsel for the petitioners that all the 5 co-complainants before the RERA whose signatures are alleged to have been forged by the present petitioner have participated in the proceedings before the Real Estate Regulatory Authority. And only after hearing both the parties, the Real Estate Regulatory Authority had passed the order, final order on 20 February 2023 in case number Assam/RERA/2017/215. Learned senior counsel for the petitioners has submitted that on perusal of the notices issued to the other co-complainants as well as on perusal of the order, final order passed on 22/2023, it is clear that the other co-complainants have participated in the proceeding before RERA and no such complaint regarding forgery as alleged in the complaint filed by the present respondent number 2 was alleged by any one of them. Stop. Issue notice to the respondents.
Number 2.
Respondent, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards the respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Call for the scan copy of the case record of CR case number 145/2023 from the Court of Learned Judicial Magistrate First Class Kamrup Metro. Stop. In the meanwhile, as it appears from the documents available in documents annexed along with the criminal petition, that the co-complainants whose signatures have been alleged to be forged by the present petitioners appears to have participated in the proceedings before the Real Estate Regulatory Authority, and the final order was also passed by the Real Estate Regulatory Authorities after hearing the parties to the case, the further proceedings of CR case number 145/2023 is hereby kept in abeyance till returnable date. let this matter be listed after 4 days.
May I please, your lordship? My lord, this is a matter, my lord, wherein the warrant of arrest had been issued against me. My lord, what has happened, my lord? I had been shown as an absconder in the charge sheet. My lord, and I am facing a trial under the NDPS section, my lord, 22C and 29. So, my lord, the warrant of arrest, which had been issued without issuing, my lord, any, my lord, the summons or something like that, my lord. So, my lord, I will appear before the learned court below with a regular bail application, my lord, and
You are
kindly
shown as an absconder.
my lord, I have been shown as an absconder, my lord. Interestingly,
No summons were issued to you.
no, before issuing this warrant of arrest, my lord, no summon had been issued, my lord.
How will we know?
My lord, this is the last order which I have annexed at page 64, my lord.
Where is the first order? Because before issuing NBWA,
No, my lord, initially, my lord, I am wrong, my lord. Initially, summon was issued, my lord. Initially, summon, yes, my lord. I have been corrected by my colleague, my lord. I am sorry for that, my lord. Initially, summon was issued, my lord, and after receipt of the summon, my lord, though I did not appear, my lord, I have presented myself through counsel and seek time, my lord, that I should be given some time, and the honorable trial court below was considerate, my lord, and sympathetically considered my prayer and allowed time. But subsequently, my lord, only in one date, my lord, I could not take steps. And also for my absence, this, my lord, warrant of arrest had been issued, my lord. So, my lord, I will continue to appear. And
on which day you could?
My lord, on, because, my lord, the last date has just passed over on 1/4/24, my lord. So the next date, I am not sure, my lord, when it has been given. Within a 10 days or 15 days from today, my lord, I will appear and with a regular bail, my lord. Until then, my lord, this warrant of arrest may not be given effect, my lord. That is
Let
my
the
only-
scan copy be there, lordship, we will see.
Let him appear. Let him, we are not,
Then court will dispose of as per law. then.
My lord.
yes,
Lower court will dispose
Yes.
as per law.
we are not giving any protection,
That
only
much.
interim protection so that he can appear before.
My lord, only, yes, my lord, only this.
Till
warrant of
appearance,
arrest.
Heard Mr.
Here, Bhuyam.
A.R. Bhuyan, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Sajid Ahmed Tapadar alias Munna, impugning the order dated 9/2/2024 passed by learned
Special judge.
Special Judge Karimganj in Special NDPS case number 12/2020.
Additional session. No?
Additional Session Judge
Mal.
Karimganj in case number so and so, whereby non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that in NDPS case number 12/2020, charge sheet was laid
My lord.
against the present petitioner under section 22C/29 of the NDPS Act 1985, showing the present petitioner as an absconder in the charge sheet. Though the trial, it is also submitted that though the trial court had initially issued summons to the present petitioner, the petitioner could not appear before the trial court and
Steps were taken.
the counsel for and the engaged counsel of the petitioner took steps on his behalf, and upon showing cause of his absence, the trial court was pleased to fix another date for his appearance before the trial court. Why you were absent?
My lord, some family, because my father, my lord, died during the course of this, my lord, and other issues were also there, my lord, which we had put in the petition, my lord.
On 9/2/2024, when the special NDPS case number 12/2020 was fixed before the trial court, the petitioner could not appear before the said court due to some personal difficulties. However, and why you did not take steps?
My lord, on that day, my lord, some communication.
Due to communication
gap
gap with the council, he could not take steps also. And the court was, and the trial court issued the non-bailable warrant of arrest against him by the said order, which has been impugned in this instant criminal petition. Learned counsel for the petitioner has submitted that the petitioner is willing to cooperate in his trial and shall appear before the trial court on next date fixed. And on, however, as non-bailable warrant of arrest has been issued against him, he only needs interim protection so as to facilitate him to appear before the trial court. So I have also had learned additional public prosecutor, considering the facts of this case as well as submissions made by learned counsel for the petitioner. This criminal petition is disposed of with direction to the petitioner Sajid Ahmed Tapadar alias Munna to appear before the Court of Learned Session Judge Karimganj in special NDPS case number 12/2020 within a period of 10 days from the date of this order. Stop. To facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against the present petitioner shall be kept under suspension for next 10 days. On his appearance before the trial court, he may pray for any relief to which he may be entitled to under law. With above observation, this criminal petition is hereby disposed of.
My lord, it should be before the additional session judgment, my appearance, my lord.
Yes, additional session.
My lord. Karimganj. Obliged, highly obliged.
Item 9.
May I please, Your Lordship. I think this criminal petition has been filed for quashing of the criminal complaint bearing CR case number 47 of 2023, which is presently pending before the judicial magistrate first class. And next date is fixed for necessary order on 8/4/2024. Lordship, basically the cases of the commercial transaction between the parties, Lordship. Money suit has been filed by the respondent number 2 for realization of that amount. And subsequently, this criminal case has also been filed. And learned trial court has wrongly taken cognizance against the present petitioner, Lordship. Now, Lordship will come to para 2 of my petition. Here, Lordship will find the crux of the allegation. What happened, Lordship, in the year 2020, month of February 2020.
Para 2 is at which?
Para 2 of my petition, Lordship. Page 4. It starts from page 3, Lordship. The crux of the allegation, Lordship will find at page 4. The crux of the allegation, Lordship, so far their complaint petition is concerned is that, Lordship, that the respondent number 2 has placed order for supplying of marks, face marks, Lordship. Accordingly, there was an agreement between them. And subsequently, invoices were issued by the petitioner. But as per their allegation, no marks has been supplied by the petitioner to the respondent. And they have paid an amount of rupees 1 lakh into the bank account of the petitioner. That is the allegation, Lordship.
Okay.
As per their statement, Lordship, the alleged incident took place in the year 2020, February 2020.
and they have filed this complaint in the month of February 2023, after lapse of lordship 3 years. In our case, lordship will find at page 7, only the relevant portion I will show. Page para 7, lordship, page 9. I have placed a document in support of my contention, lordship. Our case is that, lordship, admittedly there was an agreement, talks were going on between the parties. Accordingly, we have sent 10,000 pieces of marks to the respondent to Guwahati against the invoice number 294 through VRL Logistic Limited, which was booked on 11/2/2020, soon after placing of the order, lordship, in the month of February 2020, from Badodara, Makarpur to Guwahati by consignor Santi Engineering to consignee Royal International against LR number so and so, but the respondent did not claim the delivery of the consignment. In support of our contention, lordship will kindly come to page 75, Annexer D, because they did not claim the consignment which was sent by us. Subsequently, all the articles were auctioned by the transporter. Annexer D, page 75, lordship. This is the auction notice, lordship.
No, but in criminal petition, we cannot see.
Lordship,
defense
that is
now.
admitted position, lordship. That is why, lordship, I am just simply pointing out our contention, lordship. Presently, from the prima facie, lordship, that does not disclose any offense of section 420 or 406, because there is no question of entrustment. It is basically and purely a civil transaction, lordship, commercial transaction. As per their demand, we have supplied the goods, but subsequently, only in order to put pressure on us, they have filed this criminal petition.
If the notice be there,
Complaint.
lordship, let them appear, then lordship let this.
Lordship will kindly see the civil case, lordship, money suit. Lordship will find page 60. Page 60. Annexer C, lordship.
No elements of 420, 40 cognizance has been taken under section
403, 406, 420, and 503.
So ingredients are not there.
No, lordship, not at all, lordship. Where perusal of the complaint petition will show that only because they have put certain language in such a way to only in order to for the purpose of taking the cognizance. Will money suit, lordship, in the prayer portion.
No,
Lordship
there
will
may
find-
be a civil case, but if the facts constitute an offense, criminal case is
I'm on
not
that
barred.
only, lordship. Whether the transaction between the parties, because for offense of section 420, there must be inducement from the inception. Here, lordship,
Whether
we have
that has
already
been-
sent the consignment. They did not take the delivery.
That has been alleged or not? That there was an intention to deceive from the
Language is there, lordship. Definitely language is there.
no facts.
In fact, there is no such
Whether
offense,
facts have been alleged or not.
No, lordship. They have simply stated that we did not send the delivery. But lordship, the documents which I have placed on record, only one document, lordship. I am only placing my reliance only on one document, that is Annexer, lordship D, that we have already sent the consignment. So it cannot be said that there was an inducement from the very inception on our part, lordship. Had it been a case that we've been trying to induce them, we have not sent any consignment. But we have accordingly sent the consignment. And lordship, is their prayer, lordship, page 72 for a moment. Lordship will kindly turn to page 72. Prayer portion, lordship. Roman 2, declaration that the defendant has committed breach of contract.
They have filed civil suit.
Yes, lordship. Money suit.
Heard, Mr.
The next date is fixed on 8, lordship, on Monday. So my humble prayer would be, lordship, that till receipt of the LCR, the case may kindly be proceeding of the further proceeding may be.
What is your name?
P. Das, lordship.
Heard, Mr. P. Das.
I am appearing on behalf of A. Cabra.
Lordship, only notice, lordship, at this stage, lordship.
Heard, Mr. P. Das, learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. this application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Neeraj Verma, impugning the order dated 28/4/2023, passed by learned Judicial Magistrate First Class, Kamrup Metro, in CR case number 47C/2023, whereby cognizance of offense under section 403/406/420/503 of the Indian Penal Code was taken against the present petitioner. The petitioner has also prayed for quashing the proceedings of CR case number 47/2023. Learned counsel for the petitioner has submitted that the petitioner has that the respondent number 2 has filed a false complaint against the present petitioners, whereby the offense of cheating and criminal misappropriation as well as criminal breach of trust has been alleged against the present petitioner. It is submitted by learned counsel for the petitioner that there was an agreement between the present petitioner and the respondent number 2 for supply of marks in the year.
There was no, in fact, Lordship, written agreement. There was only discussion, negotiation between the parties.
There was negotiation
Between the parties.
regarding supply of marks. And it is alleged in the complaint petition, which is sought to be quashed, that where are the allegation?
Lordship,
Where that they have paid 1 lakh. In the complaint petition, it is alleged in the complaint petition that for supplying the aforesaid consignment of marks, the respondent number 2 had deposited an amount of ₹1 lakh in the bank account of the present petitioner through NEFT transfer and through NEFT. Stop. However, it is alleged that against the said payment, the petitioner failed to deliver any marks as agreed upon between the parties. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the complaint against the present petitioner are not true. In fact, where is your
para 7, Lordship, in the complaint petition, or in the quashing petition, Lordship, para 7,
in fact,
page 9, Lordship.
it is in fact it is submitted by learned counsel for the petitioner that in fact, in pursuant to the oral agreement, the petitioner had sent a stock of 10,000 pieces of marks to the respondent at Guwahati against invoice number 294 through VRL Logistic Limited, which was booked on 11/2/2020 from Vadodara, Makarpura to Guwahati by consignor Shanti Engineering to the consignee Royal International. However, the respondent number 2 did not took the delivery of the said consignment, and thereafter, when the said consignment was remained unclaimed with the VRL Logistic Limited, it issued auction notice and finally auctioned the consignment of 1,000 marks, 10,000 marks sent by the present petitioner. It is also submitted by learned counsel for the petitioner that the dispute between the present petitioner and the respondent number 2 is civil in nature, predominantly civil in nature. And with regard to the same dispute, the respondent number 2 had also instituted a money suit against the present petitioner, in which he has claimed breach of contract. He has alleged breach of contract against the present petitioner. The
Same is pending before the civil judge number.
the said money suit has been registered as money suit number 25/2023 and presently pending before the Court of London, Civil Judge number 1,
2 Lords. Civil judge number
Judge number
Kamrup
2, Kamrup Metro at Guwahati. So, learned counsel for the petitioner has also submitted that on perusal of the complaint petition filed by the respondent number 2, no facts which constitutes the ingredient of offense under section 403 or 406 or 420 or 4503 has been narrated in the said complaint petition. So, issue notice to the respondents.
Respondent number 2 Lords.
As learned additional public prosecutor has appeared for the respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. As prima facie on the basis of annexures and documents placed along with the criminal petition, it appears that the dispute between the petitioner and respondent number 2 is predominantly civil in nature, and it also appears that civil in nature, further proceedings of CR case number 47C/2023 is kept in abeyance till next returnable date.
Lords.
List accordingly.
Obliged, Lords. Deeply obliged.
Kindly, please, my lordship, page 12, man. Then we read the FIR. Sir, I would like to inform that I was instructed to cause an inquiry upon the illegal loan sacking racket under Golaganj PS. I, along with staff, made an inquiry to the different places of under Golaganj PS, and I consulted with the leading persons of the localities. The below mentioned loan
Let us
sacking.
CDB there, Lordship.
No,
Let
madam.
him submit.
The below mentioned loan sacking business have been running this kind of business to the needy people with high rate of interest. Somehow they keeps ornaments, motorcycle as surety. Whenever the borrowers are not paying the interest, they may conspiringly torture them. They used to increase the rate of interest and illegally demand money from them. They have been threatened and humiliated by taking the advantage of pauperism. On the other hand, some of them threatened the victim people to kill if they found a loan. Somehow they cheated people by demanding extra amount after completion of the whole debt. This kind of loan-seeking businessmen have been cheating the people for a long and used to make huge racket at the locality by extorting people in exchange of loan-sacking business. Now, my lords, there are 7 co-accused. My lords, no victim has come forward. The entire FIR is vague, unclear, and also vague and there is no strict cause of action. Which property? Who are the borrowers? There is nothing. My lords, accordingly, I filed a pre-arrest application before the additional district judge. It was rejected. My lords, please come to page 16. My lords, please see the reasoning. I have pursued the case diary available before me. Upon pursuit of the case diary, it can be observed that the present accused person is an FIR named accused. That apart, a similarly situated co-accused Pradeep Roy, PRS application is already rejected by denied. So and so. So, my lords, there only my bail application has been rejected only 2 grounds that my name has been is in the FIR and PRS application of a co-accused has been arrested. Now, my lords, please come to page 18. Now, my lord, Krishna Pada Saha, he is also a co-accused and he was arrested on 25/2/2024. My lords, he was granted bail and my lords, see the reasoning. But surprisingly, it is seen that no section for the panel provision is grouped for the offense of money laundering business of the accused persons. The informant has lodged the izahar against as many as 7 persons, including the accused Krishna Padasa. In the meantime, the IU has seized some gold ornaments in the instant case and also recorded the statement of the 3 seizure list. Witness, including the statement of the informant and 3 witness, and the statement of the accused was also recorded. However, so far, the IU could not collect materials from the victim or any borrowers in order to establish prima facie that the accused had demanded extraordinary huge rate of interest against any loan transactions or committed the offense of extortion by putting any person under any threat or dire consequences. My lords, in Assam, we have Assam Money Lenders Act. My lords, even if we assume that all the allegations is true, it will be the Assam Money Lenders Act which will be come into play, in which the maximum sentence is, my lord, 6 months. So means I may be protected, my lords.
Lordship, it is AB Lordship. He is submitting, that is, he is a BA Lordship. That was BA. So we will bid the CD on short date Lordship.
No, my lords, please come to page 18, my lords. It is
Okay, we'll be call for the CD.
CD Lordship. Till then Lordship.
my lords, please.
You appear before the IO. Mr. What is your name?
DK Agarwala.
DK
Agarwala.
Agarwala, learned counsel for the petitioner. Also, Miss A. Begum, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Manoj Devnath, who is apprehending his arrest in connection with Golokganj PS case number 35/24 under section 120B/384/387/406/420/506 of the Indian Penal Code. The gist of accusation in this case is that on 24/2/2024, one Bidhan Chandranath, SI of Police of Golokganj PS, had lodged an FIR before the officer in charge of Golokganj Police Station, inter alia, alleging that the informant was instructed to cause an inquiry upon the reported incidents of illegal loan racket under Golagganj police station, in which it was alleged that the 7 numbers of accused persons listed, named in the FIR, including the present, what is the name of the present petitioner?
Manoj Kumar Devnath.
Including the Manoj,
Devnath.
including the present petitioners, used to give needy people loan at a huge rate of interest, and when they fail to repay back the said interest, the accused persons used to threaten and humiliate them, taking advantage of their ignorance, and also threaten the victims to kill them. It is also alleged that the accused persons named in the FIR are doing the said business since long time. Learned counsel for the petitioner has submitted that apart from naming the 7 numbers of persons in the FIR, no specific allegation against a specific victim or a particular instance has been narrated in the FIR, and only general allegations are made against the accused persons named in the FIR. Stop. Learned counsel for the petitioner has also submitted that in this regard, one Krishnapada Saha, who is the accused number 1 named in the FIR, was arrested. However, he was later on granted bail by the Court of Learned Chief Judicial Magistrate Dhubri on the ground that no materials to establish prima facie allegation against the said accused would be found in the case diary. Learned counsel for the petitioner has submitted that even if, though no specific allegation has been made against the present petitioner in any specific case of giving loan at a higher rate of interest, however, even if the allegations leveled against the accused are assumed to be true, it falls within the purview of Assam Money Lenders Act. Which year?
1932.
Kind of Assam Money Lenders Act. And under the said act, the offences are bailable in nature, and maximum punishment is 6 months only. On the other hand, learned additional public prosecutor submitted that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Stop. Call for the case diary. 854 case diary. However, considering the fact that no specific instance or specific allegation has been leveled against any of the accused persons named in the FIR, including the present petitioner, as well as also considering the fact that one of the co-accused was released on bail. The accused number 1 was released on bail after perusal of the case diary, wherein the court granting bail had observed that no prima facie material was found against the accused person, the present petitioner is directed to appear before the investigating officer of Golokganj PS case number 35/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Golokganj PS case number 35/2024, the above named accused person shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this matter be listed again on 13/5/85.
That's some money in this 1934.
Moneylenders Act 1934.
Much obliged.
Mayor, please, and also 438 application minors, FIR space 11. The operating portion from para third, my lord, may I read?
Yes.
Which refers to the subject cited above, I beg to inform you that Havinsar Saurabh Borgohain, son of so-and-so, who was in charge of Shivsagar's hub and he is found involved in cash misappropriation and has not deposited sum of rupees so-and-so in company account. During the case audit on 13th November, Mr. So-and-so, area manager, was able to figure out that Havinsar Saurabh was rotating the cash on delivery amounts and deposition is not happening timely. Upon asking about the cash rotation, he has accepted his wrongdoing. There is 464 numbers of shipments missing from office, which is worth of so-and-so during his tenure. Due to his misconduct, breach of trust against the company and integrity issue, the company is facing huge loss of rupees so-and-so. This is the allegation and FIR registered under section 420, 406 and 407. Actually, what happened in this case, my lord, the petitioner is a hub in charge of the said lordship.
Who is petitioner?
Saurabh Borgohain.
What he does?
He is the hub in charge of the
Hub in charge.
hub in charge.
Okay.
This is the company storage of online shopping companies. That is the
Amount is a huge amount, Lord. So yes, there will be required.
Let her submit.
Lordship. Lordship, his duty is that he has to identify the products and record of the dispatching goods and assuring the quality of goods. His duty is on the he has to do that type of duties, my lord. And the delivery person, they dispatch the delivered the goods and collected money. Petitioner is no way involved with the money deposited to the company, my lord. And so far as the allegation is concerned, he is nowhere involved with the collection of money and even assuming, but not admitting, my lord. Then alternative remedies are available to the company, and informant is the an executive of the company. He is not a manager. That is the for last paragraph, my lord. One Mr. Uttam Nayak, area manager, who found that at the time of audit, the deposition is not happening timely. Allegation is there. Not saying that he is not deposited, even assuming the duty of the petitioner is supposed to deposit the money in the company account.
No, but some deposit was found to be missing.
missing.
41,000.
No, so even assuming, my lord, this is all
Or-
the evidence is from the documentary evidence.
No, it's
Yes,
lordship, 4 lakhs, lordship.
Yes.
4 lakhs, 15,571.
Documents will show, my lord.
Yes.
So let the CB be there, lordship. Their own admission.
First, some shipments are also missing, lordship.
Okay, no, question is whether his detention is required.
Lordship.
CD will reveal, lordship, that
No, whether you are searched for being arrested, whether police is searching you or not.
Documents will reveal, my lord. But the informant is not a area manager.
if nothing is there, lordship, she will liable for the bill, lordship. So
No, whether police is searching you,
Lordship, because name is mentioned directly in this
but
paper.
police is not searching them.
Searching for me, my lord.
Where is the statement?
Lordship,
You have not made such.
lordship.
apartment to go to.
If police is not searching you, we will call for the case diary.
Twenty to 4, lordship. So this
Let us see the case diary.
20 to 4.
Third miss. What is your name?
P. Bora, lordship.
Heard
P. Bora.
Miss P. Bora. Learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Saurabh Borgohain, who is apprehending his arrest in connection with Sibosagar PS case number 5/2024
In para 8, I have stated.
under section
Search.
420/406/407 of the Indian Penal Code. In para 8,
Lordship,
show me.
Lordship, last para 8, page number 5, para 8, last para, it is stated by the petitioner in connection with the incident case. Police searching for the petitioner and
Okay.
in
The
apprehending
gist
of
of accusation in this case is that the area manager that one Shri Krishna Upadhyay had lodged an FIR before the officer in charge of Sibsagar Police Station, inter alia, alleging that the present petitioner, who is the hub in charge of which company?
in Instacart Service Private Limited,
Hub in charge of
Sibsagar Hub. In FIR, first paragraph, last line, my lord.
Instacart Services Private Limited, Sibsagar, and has not deposited an amount of rupees 4,15,751, which was found to be found to be missing. No, which has not deposited an amount of 16 lakh. No, the allegation is more in para 3.
Para 3, my lord, misappropriation has not deposited sum of rupees 16,99,567 in company account. Thereafter, during
16,99,567 in company accounts. And it was also found that 464 numbers of shipments worth rupees 4,15,571 was missing from the office during his tenure. Stop. No, case diary would be required.
Lordship,
22, Lordship.
We were fixing short date,
this is the audit report, my
but the allegation is 16 lakh. You have misappropriated 16 lakh.
delegation, my lord.
Let us see the case diary.
Lordship, may kindly
22, Lordship, 22-4. After opening.
Stop. Considering the nature of allegation level in the FIR against the present petitioner, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary, fixing 22-4 after case diary, 22-4 for case diary.
Lordship.
Oblate.
My lord, FIR is at page number 1313, my lord. My lord, the FIR is lodged against a store manager, my lord, by the owner of the store, alleging that, my lord, he has stolen 40,000 and 20,000 rupees, and there was a shortage of stocks amounting to rupees 8 lakhs. Now, my lord, I'll
It
read
is
the
similar to the earlier
Yes,
case.
they're similar. I go to Bele.
You are store manager.
store manager.
Earlier one was hub
Same
manager.
case, same offense.
No, it is just similar.
Similar.
You
my
may
lord,
continue.
my lord, all criminal cases at the end of the day ends up in the jail, my lord. So some similarity. My lord, now, my lord, this
Lawyers are also similar.
absolutely. My lord. Now, my lord, the allegation, this FIR has been drafted ensuring that certain ingredients of criminal, my lord, of IPC are there. But, my lord, howsoever one tries, my lord, at the end of the day, my lord, the truth surfaces.
The case was registered under section
The case was registered under section
408.
408 is up to 7 years, my lord. Extend up to 7 years. So 41A is also mandatory, my lord. Now, my lord will kindly see no date whatsoever is mentioned, simply a vague allegation in in the second paragraph. Furthermore, it revealed that Mr. Surojit Rakshit has stolen cash from the retail store, including 40,000 and 20,000. My lord, on which date? How he came to this breakup? Can the liberty of a man be tickled so easily, my lord? Then he said that there is a shortage of stock. Every store in city center mall, my lord, there are CCTV cameras. When he has, or how he is being responsible for the shortage of the stock. What stock? Not even a prima facie mentioned. What stock? It is shirt, pant, what sort of a material? From where these magical figures come? My lord, the fact is that he is not in a good relation with the management, my lord, because the management was not giving him leave to attend his grandmother's, my lord, ill health. Simply he's been saddened with this, my lord. My lord, at the end of the day, 60,000 is the allegation. Let him go and appear. Let him give his version, my lord, whether he is responsible or not, my lord, because until now, except this FIR, my lord, the management was behind him. Now the police are also behind him.
Lordship,
My lord,
after
this
receiving
court-
of the affair.
My lord, I am never saying that I am never saying, my lord, that the case diary will not be perused. That's not even my argument, my lord. What I am saying is that at least, my lord, his version should also come on record, my lord. And thereafter, my lord, if anything is there, your lordship is always at liberty to cancel the bail, my lord. Because, my lord, the amount is also meager amount of 40 and 20, a strange breakup without any date. And stock, it is impossible, my lord, because all the, my lord, stores in shopping malls, the CCTV cameras are installed. On such a vague nature of allegation, my lord.
Your main ground is
He
that
disappeared.
dates are not mentioned.
Nothing, my lord, there has to be some specificity, some, my lord, some semblance of truth, my lord. Simply I say that Mr. Such and such has taken this much amount stolen, misappropriated, something, my lord.
Lordship, it was discovered during internal audit. Date 1st March, so and so there was substances of stock amounting, date is there, Lordship, when the audit is done, Lordship.
No, my lord, what is written is that on that day they have come to know when these things were done, my lord. Every day when the stores are closed, my lord, proper accounts are made on every day, my lord. And nowadays all billing in all shops are computerized. No handwritten bills are, my lord, given to any customers. Everything has an entry in the computer.
Now, when the FIR is alleging that upon internal investigation, it was revealed that you have intentionally manipulated the stocks, leading to abnormal shrinkage.
My lord.
What is your submission?
Absolutely. My lord, who is doing this? It is their own people. Internal audit, my lord, it is not an impartial auditor. It is their own man who has lost this FIR. He has made this investigation. The word investigation is used, my lord. It is his perception. Things will come only a proper investigation is done by the police, where I will also cooperate. This is, my lord, because my lord will see the last paragraph, the choice of the words. Engaged in cheating, theft, gross violation of the company's policy, breaching the trust and confidence bestowed upon him. My lord, my only submission is that, my lord, since the amount is not that much high, my lord, it is 40,000 and 20,000. Let this man, my lord, have an opportunity of give him an opportunity to give a statement, my lord, so that, my lord, the police will also have an idea that whether, my lord, this man is actually guilty, and if anything such surfaces from any of the documents, then, my lord, your lordship will always have a liberty. My only apprehension is that, my lord, due vacations are impeding next week, my lord.
Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Ms. M. Begum, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Patit Rakshit, Shri Surojit Rakshit, who is apprehending his arrest in connection with Dispur PS case number 184/2024 under section, what is 408?
408, that is criminal breach of trust by clerk or servant, extend to 7 years.
Section 408 of the.
There is also misappropriated 8 lakhs something, Lordship.
No, that is stock.
Stock 8
That
lakhs,
is
stock is
Shrinkage
8.
of stock.
Sinkage of stock. That is no stolen.
408. What was the last name?
Oh, nice applicant.
of the Indian Penal Code. The gist of accusation against the present petitioner is that one, who lost the FIR?
FIR is lost by Deepak Kumar Gupta. My lord will find it, dear sir, page 13 top.
One Deepak Kumar Gupta of H&B Stores Limited had lodged an FIR before the officer in charge of Dispur Police Station, inter alia, alleging that the present petitioner was working as store manager in new U store located at the second floor of City Center Mall, Guwahati. And it has been found during internal investigation that there was an abnormal shrinkage of stock amounting to rupees 8,77,363, and during internal investigation of the company, it was revealed that the present petitioner had manipulated the stock records, leading to abnormal shrinkage. It is also alleged that the present petitioner had stolen from retail store an amount of rupees 40,174 and 20,000 stop. On receipt of the said FIR, the Dispur PS case number 184/2024 was registered under section 408 of Indian Penal Code. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner are not true. In fact, it is submitted that the present petitioner does not have good relationship with the management of the company, and therefore he is tried to be implicated in this case. It is also submitted by learned counsel for the petitioner that the petitioner is not at all shrinkage of stock which has been reported in the FIR, and apart from mentioning that during an internal investigation it was found, however, nothing has been revealed as to what stocks were found short from these stock records. It is also submitted by learned counsel for the petitioner that though allegation of theft of rupees 40,174 and rupees 20,000 has been made against the petitioner, however, nothing has been mentioned as to on which date and under what circumstances the petitioner has the allegations on which date said money has been stolen. Stop. What else your submission?
These are primarily, and my lord, he will cooperate, my lord. He will go and he will give a statement. He is willing to cooperate, my lord. Let the truth surface, my lord. The management may also come under the purview of this investigation. If somebody else is responsible, his statement is necessary, my lord. He will cooperate with the investigation as and when called upon.
Now, suppose you are responsible for the shrinkage, leaving apart the 40,000 and 20,000, that shortage of stock, which is alleged against you.
Now, my lord, there are two things, my lord. Because, my lord, one person in a store can never be responsible for the entire sinkage. Now, my lord, in case one is, it is deliberate. One is, my lord, that by negligence. If it is by negligence, then a civil suit will lie, my lord. If it is deliberate, then a criminal. My lord, for all these things, my lord, because now this man is
Learned
not.
counsel for the petitioner has also submitted that there are CCTV installed in city center mall as well as the
Yes,
store.
stores.
And therefore, any shrinkage would be noticed immediately. However, nothing of that sort has been alleged against the present petitioner. Learned counsel for the petitioner has also submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary.
Objection may be recorded, Lordship.
And she has also objected regarding grant of any interim bail to the present petitioner. Perusal of the case diary would be necessary, hence call for the case diary fixing 3rd May for case diary. However, during this period, considering the fact that no specific dates have been mentioned on which the accused has allegedly committed the theft of rupees 40,000 and rupees 20,000, and regarding shrinkage of the stock, it is found only from the stock records, and therefore the allegation is only of manipulation of stock records, and the stock records are available with the company. Therefore, if the petitioner during this period, before arrival of the case diary, cooperates with the investigating officer, would not be in a position to, and as the records are in the possession of the company, the petitioner would not be in a position to do any tampering with the said records. Hence, the petitioner is directed to appear before the investigating officer of dispute PS case number 184/24 within a period of 10 days from the date of this order, and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with dispute PS case number 184/24, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. Let this case be listed again on 3rd of May.
I'm deeply.
May I please? This is 438 application. FIR is at page 8 lawsuit. And the relevant is from page 9. This is a long FIR regarding lawsuit business transaction. And lawsuit, I will take only the relevant part of this FIR lawsuit. Page 9.
Page
9. Contextual work that has been carried out lawsuit by the informant as per the agreement is carried out by the petitioner as per the agreement made by the parties lawsuit. Lordship, page 9. With due respect, I understand that to state that I am a lawful attorney holder of a firm, namely so-and-so engineering, owned by one so-and-so, resident of so-and-so. In the year 2015, said the so-and-so, through a general power of attorney, authorized me to run the business of the said firm, as well as to do other analogous work. It is pertinent to mention here that so-and-so basically deals in supply work to various institutions of the government and private sector. The said firm has its registered with so-and-so. Well, in second paragraph, it is pertinent to mention here in that the work of the opposite firm, so-and-so, is also looked after by one part-time employee, namely Prakash Agrawal. Well, I am Prakash Agrawal and my son also. Well, here, kindly this point may be noted. Here he has mentioned, withholding the lordship actual fact, he has mentioned that I am a part-time employee. The lordship will kindly note it. Resident of so-and-so, so-and-so, visit the office, marketing so-and-so. My lord, your lordship may kindly come to page 10. Skipping the paragraph 1 and 2, your lordship may paragraph 3. This is the work order, lordship. Accordingly, 2 numbers of work order were obtained by so-and-so engineering from Assam Government Marketing Corporation Limited, Ambari, so-and-so, dated one is lordship 21/1/2016, and another one is 6/2/2016. These 2 works order were obtained by the informant in the government. Execute Assam government, so-and-so, understand. On the lordship, the next paragraph. On the strength of affirmation to supply orders, the firm common engineering is supplied so-and-so, portal and to various institutions under Assam Government Marketing Corporation till date. Next paragraph 18. Against the supply work orders, the firm so-and-so in the year 2020 received 2 numbers of check amounting to rupees 78,000 lakhs 56,657, and this is the amount mentioned regarding the check. And opposite 2 checks were duly deposited in the bank account of the firm so-and-so, maintaining the State Bank of India so-and-so, and same were credited into. And this amount was received by the informant himself. The subsequent to the last paid aforesaid check in the year 2020, the firm so-and-so carried out the supply work under the aforesaid works orders and accordingly submitted his bill periodically before the office of so-and-so. That out of our firm so-and-so, despite submitting supply bills on regular interval in the office of the government of Assam, so-and-so have not received any payment from the said office since 2020 till date. Considering this same, the undersigned, so-and-so opened a bank account number so-and-so at Indian Bank, so-and-so deposited the aforesaid 4 numbers of check on various dates. The amount of 4 checks were duly credited in the bank account on so-and-so, that on inquiry, it has further come to light that the said bank account has been operated by on Madhurjo Das. The total amount is rupees so-and-so 1,73 lakhs and something. Credited therein through the aforesaid 4 checks was later on transferred through bank RTGS to the respective personal account of Prakash Agrawal, he is the petitioner number 1, and his son, Ishan Agrawal, he is the petitioner number 2. On various dates, and some portion of the amount was also withdrawn through self-acquisition. This is the basic allegation that amount was credited in the bank account of one Madhurjo Das, and Madhurjo Das has transferred this amount to the bank account of the present petitioner. This is the whole allegation. And so far the lordship agreement is concerned between the informant and the present petitioner. Lordship, that I have brought through an additional affidavit. Your lordship may kindly come to the my lord.
This has been transferred to your account.
Yes,
on various dates.
My lord.
Thereafter, what is the allegation?
Yes, lordship.
Now, this transfer is a
Last paragraph.
They
have make a fake account, lordship.
My lord, page 13, the allegation. From the fact stated above, Prakash Agrawal and his son Ishan Agrawal, in connivance with the concerned authorities of the Assam Government Marketing Corporation Limited, Ambari, managed to receive the 4 numbers of payment checks of so-and-so from the said rupees amounting to rupees that loss of 1.73 lakhs in total by forging my signature and thereby misappropriate the said amount.
This
Further-
forgery is the allegation.
Yes, further is the allegation. My lord, furthermore, Prakash
And
Agarwal,
misappropriation.
my lord, and his son Ishan Agarwal with the help of one Madhujo Das by opening fake account in the name of so and so, and shipment of the entire amount, and thereby they also committed an offense of money laundering. Under the opposite facts undersigned in so and so. My lord, agreement that we have lordship executed between the parties lordship, your lordship will kindly, I have brought it in lordship through additional ability that your lordship may kindly come. Because the entire work lordship that has been carried out by the present petition and the materials were supplied by us as per the agreement. My lord, page 29.
Whose money was this? 1 crore.
My lord, that money was that is the contract amount against the supply work
Supply
given-
work was given to Coming Engineering.
No. Actually, work order was issued in favor of Common Engineering.
Yes.
But Common Engineering lordship has made an agreement with the present petitioner to carry out the work. Accordingly, lordship, we supply the materials to the government. My lord, page 29 is the memorandum of understanding between the informant and the present petitioner.
For?
My lord, page 29.
No, for what?
Regarding lordship, the agreement between the informant and the present petitioner to carry out the works and certain terms and conditions is given. Your lordship, two works order that has been mentioned in the FIR that your lordship will find at page 30, second paragraph. These two works order, against these two works order, the agreement was made between the parties. That is, one is 21/1/2016 and another one is 6/2/2016.
No, who has transferred the money to your account?
My lord, that as per allegation, this is Madhujo Das.
Who has transferred the
Madhujo
account?
Das, he is the representative of the Common Engineer.
Okay.
My lord, admittedly that amount has been credited and we have received that amount. We are not disputing.
Okay. So you are saying that it is in lieu of the work done by.
Yes, and that was authorized by the informant. Lordship, I have annexed all those documents. Authorization letter itself. This is the agreement, and your lordship will find the authorization letter that is page 21 in my petition, lordship. And only to realize that money, lordship, and to that effect, I also filed an FIR against them because they were pressurizing and creating lordship threatening to the petitioner. Lordship, kindly come to page 21 in my petition. This is the authorization letter given by the informant to the petition number 1.
Page?
Page 21.
What is this?
This is the authorization letter given by the informant to the petitioner number 1.
For what? For doing?
My letter, yes, that is so and so. Sandeep Garodia is the informant. To do hereby authorize and appoint one Sri Prakash Agarwal, son of so and so. That is in terms of the agreement, lordship. Agreement was there. To collect documents, to sign, to receive payment, and to appear before any forum on my behalf. And lordship, after receiving that amount, lordship, he made a threatening, and to that effect, lordship, I also lodged an FIR prior to his FIR, lordship. That is page 22. That FIR, although that FIR is received, lordship, page 22.
Now, what have you alleged in that FIR?
My lord, that is.
No, just what
Just
have you alleged?
lordship, after getting receiving that money by
This
us,
1
lordship,
crore.
1.73 lakhs. He has creating pressure to the petitioner to give this money to him, and a threatening was also made to of dire consequence that we have alleged the FIR. Lordship, if your lordship can be page 22.
Okay. Yes, very would be.
Is there this is absolutely lordship out of business transaction in
No,
nature, lordship.
you appear. Let
Lordship.
him appear.
No, lordship, after receiving of the diary, lordship, it's a huge amount, lordship. And he
The
have
amount
brought,
is not disputed.
Him. They have materials
Lordship,
to.
open a fake bank account in the name of the say, name and style of,
But there is an memorandum of understanding between them.
that was on 2018,
If
Lord.
there is any material, we will reject it.
Yes, absolutely.
Interim basis. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 438 of 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Prakash Agarwala and his son Ishan Agarwala, who are apprehending their arrest in connection with Bhangagar PS case number 31/2024, registered under section 120B/420/406/468/471 of the Indian Penal Code. The gist of accusation in this case is that one Sandeep Kumar Garodia who is the lawful attorney holder of the a firm, namely Kameng Engineering Bhalupong, had lodged an FIR on 16/3/2024 before the officer in charge of Bhangagar Police Station, inter alia, alleging that the petitioner, by forging the signature of the first informant, had misappropriated an amount of rupees 1,73,11,010, which was allegedly transferred into the account of the present petitioners by one Madhujyo Das from his own account. No, Madhujyo Das from the account of the present petitioner. No, from the account of the informant.
Informant.
The
In
said
connivance
account,
with both lordship.
said
the
account
transfer.
was operated by the
So
by-
RTGS has
by one
transferred.
person, namely Madhujyo Das. It is submitted by learned. It is also alleged in the FIR that it is the Kameng enterprise which got the work order from two work orders from the Assam Government Marketing Corporation Limited and the allegation in the FIR is also against the authorities of Assam Government Marketing Finance Corporation Limited, that they have also connived with the present petitioners in facilitating the payment of 4 numbers of checks of Kameng Engineering Bhalupong amounting to rupees 1,73,011
73 lakhs.
73,11,010 to the present petitioner. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. He has submitted that there was a memorandum of understanding between the coming enterprise and the firm of the present petitioners to execute the work order, execute both the work orders mentioned in the FIR. Work orders from the government, Assam Government Marketing Corporation Limited mentioned in the FIR. It is also submitted that as there was a memorandum of understanding that the work would be executed by the present petitioners, and authorization letter
Page 21.
to authorization letter to receive payment on behalf of the first informant of the FIR was also given to the petitioner number 1. And it is submitted that as per the said arrangement, the money was transferred to the account of the present petitioners after they have executed the work of the said work orders as per the memorandum of understanding between the petitioners and the informant of the FIR lodged against them. Learned counsel for the petitioner has also submitted that after the money was transferred to the account of the present petitioner, which the petitioners are not denying, the first informant of the first informant, namely Sandeep Kumar Garodia, resorted to threatening them, and due to which the present petitioner were compelled to lodge an FIR against the said Sandeep Kumar Garodia. Where is the FIR?
My lord, although that has been filed page 22 and a receiver that has not been registered, they are saying that these are business transactions, we cannot do anything. That a receipt is page 25.
Sandeep Kumar Garodia. It is also submitted that though the FIR was received by the officer in charge of Paltan Bazar Police Station, however, no case has been registered, citing that the dispute between the parties is a business dispute.
Yes.
Learned counsel for the petitioner has also submitted that if any dispute is there between the parties, it is of civil nature, and the petitioner is ready to cooperate with the investigating officer. On the other hand, learned additional public prosecutor has submitted that as huge quantity of amount is involved in this case, the perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary. Fixing?
Objection may be recorded, Lordship.
Fixing 8-5 for case diary. Learned counsel for the learned additional public prosecutor also objected to grant of any interim relief to the petitioner at petitioners at this stage. Stop. However, considering the materials on record, including the memorandum of understanding executed on 5th of March between the Coming Enterprise and the firm of the present petitioner, as well as the authorization letter issued in behalf of authorization letter issued to the petitioner number 1 by the first informant of the FIR, the present petitioners are hereby directed to appear before the investigating officer of Bhangagarh PS case number 31. Bhangagarh PS case number 31/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Bhangagarh PS case number 31/2021, both the above named petitioners shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, condition number 1 and 2. Let this case be listed again on 8/5.
Made please, your lordships. It's a 438 application, your lordships. The petitioners, the petitioner number 1 is working under a regional recovery head of Shriram Transport Company, and petitioner number 2 earlier was branch manager of the said finance company, who are the finance company has been is functioning the loan to the new vehicle as well as reused vehicle, your honor. Now the petitioners having come to know that one FIR has been lost by Makum PS, annexure 20, page 22, annexure annexure B, page 22. The FIR has been lost on 14/10/2023, last year, October, your honor, 22. May I read the FIR, your honor? Most respectfully, I beg to inform you that I purchased a vehicle truck bearing number so and so from Sri Ranjit Kumar Gupta, son of so and so, a resident of so and so, by entering into an agreement before the notary public so and so by the serial number dated 4/5/2023. That is important. 4/5/2023. At a consideration of ₹8 lakhs. It is pertinent to mention herein that one Binanda Moran, son of so and so, resident of so and so, was the original owner of the said vehicle. He sold the said vehicle to the aforesaid Sri Ranjit Kumar Gupta. He sold the vehicle to the Ranjit Kumar Gupta, from whom I have purchased the vehicle, and thereafter I got the registration of the said vehicle transferred into my name from earlier owner. After purchasing the said vehicle, I and said Binanda Moran entered into verbal agreement for engaging my said vehicle with him for purpose of supplying LPG cylinders from the IOCL, Digboy, to different gas agencies, and accordingly I have handed over the said vehicle to my my said vehicle to Sri Binanda Moran on 22/9/2023. That is important date. At about 8 p.m. Sri Binanda Moran called me over phone and informed me that a few moments back some persons came at his place at Digboy Road, Makum, and introduced themselves as officials of Shriram Finance, forcefully took away my said vehicle by saying that there is a loan pending against my said vehicle. It is to be mentioned here that my said vehicle is never hypothecated with Shriram Finance, and as such Shriram Finance has no way authorized to take away my said vehicle at the said manner without my consent and knowledge. Hence, I made the branch manager of Shriram Finance, Tinsukia branch, was admitted that they have taken away my said vehicle as Sri Ranjit Kumar Gupta took the loan by mortgaging the said vehicle. But when I wanted to provide me the copy of the documents regarding the mortgage of the said vehicle or to return my vehicle, he refused to do so. Thereafter, I called Sri Ranjit Kumar Gupta repeatedly over his phone, but he also
has not been responding to my calls. Sir, I am quite sanguine that my vehicle is genuine, is never mortgaged or hypothecated with Serum Finance. And as such, branch manager along with other officials of Serum Finance have intentionally, dishonestly and forcefully take away my vehicle without my consent and knowledge, and on being approached them, they have refused to return the same to me and thereafter cause wrongful loss to me and put me to immense financial loss. Now, before your lordships, he said Ranjit Gopal Gupta has came to the finance company by entering into an hypothecated loan agreement, which is Annexure F page 30, on the basis of the NOC, NOC page 29, Annexure E page 29. Binod Moran has issued an NOC to finance company that he has no objection if the finance company has financed the refinance and
Sumit Kumar Shah.
Sumit Kumar Shah.
He purchased the vehicle from Ranjit.
Ranjit Kumar Gupta.
Who purchased it from Binod Moran?
Ranjit Kumar Gupta by your Annexure E.
No, Ranjit Gupta purchased it from
Binod Moran.
Binod Moran.
The Annexure E, page 29. And the loan hypothecation has been duly been executed and we have financed the vehicle. Thereafter, Your Honor, due to default in payments, he on 23/9/2023, Annexure I,
Page
52, he surrendered the vehicle before the finance company. Page 52, Annexure I on 23/9/2023, stating that I have voluntarily surrendered the above vehicle to the representative of Serum Transport Finance Company Limited in accordance with the rights vested with the Serum Transport Company Limited as per schedule of the said agreement, whose terms and conditions I have violated by defaulting. The word is defaulting in the schedule repayment of the above loan. He has voluntarily surrendered his vehicle, and the vehicle has been kept in a parking yard with all proper following due procedure. Annexure J, 50 page 54, has been parked at Chobe parking at Tinsukia. A inventory has been made, page 54, Annexure J, which is already been signed by the Ranjit Kumar Gupta. Then somehow during the vehicle has been laying idle in the parking place, the informant has somehow, with the connivance of the officials, have registered his vehicle in his name. Though the informant is knowing that the vehicle has been financed by the finance. Dated Annexure K, page 57, on 4th May 2023, the agreement which has been mentioned in the Interim FIR. They stated that he has no knowledge that vehicle has been financed, but from the facts, the documents, it has been revealed that the informant has knowing that the vehicle has been under the finance of the finance company, that is the Serum company. Page 58, the one paragraph, it is clarified. Page 58, and paragraph number 5. Page 58, paragraph number 5. That the purchaser shall realize the loan amount of rupees 3 lakhs to the finance company, which is remaining outstanding at present. Then that agreement has been executed between Ranjit Kumar Gupta and Sumit Kumar Shah. That the informant has known that the vehicle has been under the finance company. Then the lordship, in connivance with all that to mislead the entire thing, your lordships, the Interim FIR has been lodged out against the branch manager and his entire officials of the company, your lordships, for which the entire officials, these petitioners are in fear for performing their regular duties. Your lordships, the very interesting that the vehicle has been seized from the parking place, that is Annexure L, page 62. At the behest of the informant, page 62, the owner is Prakash Chobe. He has been identified.
Parking, which parking place?
Is a Chobe parking place,
Not from your premises.
not from my premises.
And you have stated that the vehicle was surrendered to you by Ranjit Gupta.
And the vehicle has been after vehicle has been surrendered, it is a process that the vehicle has been kept in a parking place with which is Chobe parking, owner by the Prakash Chobe. Now, your lordship, there is no 41 FIR, 41 notice has been given out. The entire FIR has been made out that it's a criminal to make it a criminal case to indulge all the officials in the false case, your honor. So the apex court and the apex court and these our honorable high court judgment regarding the Tata Motors versus Bonali Bora Dr. Bora's case.
What it says?
The because deduction Charanjit Singh says apex court has says if there is no dishonest honest, the impugn the section 379 has not been came up.
No, now the question is why you have approached this court.
Because of the FIR has been registered and the police is searching me, the entire officials, your honor. Because I have on the strength of the impugn FIR, I may be arrested at any moment, your honor.
Police is searching you.
Lordship.
Lordship, let him record his statement. Till then, we'll call the CD lordship.
And I may be protected, your honor. And
thank you.
Heard Mr. H. Borwa, counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Pranjal Pratim Buragohai and Krishna Mishra, alias Krishna Kumar Mishra, who are apprehending their arrest in connection with Makum PS case number 5/2024 under section 379 of the Indian Penal Code. The gist of accusation in this case is that one Sumit Kumar Shah on which date FIR was lodged?
FIR dated next 14/10.
14/10/2023.
14/10/2023.
Had lodged an FIR before the officer in charge of Tinisukia Police Station, inter alia, alleging that he had purchased a vehicle within bracket truck bearing registration number AS01GC 0135 from one Ranjit Kumar Gupta, who had earlier purchased it from one Binando Moran. Stop. It is alleged that though the said vehicle, it is alleged in the FIR that though the said vehicle was not under any hire purchase agreement, however, on 22/9/2023, the officials of Shriram Finance forcefully took away the said vehicle, stating that there is a loan pending against the said vehicle. Stop. On receipt of the said FIR, Makum PS case number 5/2024 was registered under section 379 IPC. Learned counsel for the petitioner has submitted that the vehicle which was seized in connection with this case from a parking lot was purchased. Who took loan from you? Ranjit Gupta.
Lordship.
Was purchased on the basis of an hire purchase agreement entered into between the Shriram Finance
It's a hypothetical term. It's a hypothecation.
hypothecation from finance on finance by Shriram Finance Company to the late to Shri Ranjit Kumar Gupta. And as there was an outstanding due against the said loan on 23/9/23, said Ranjit Kumar Gupta had surrendered the said vehicle himself to the Shriram Transport Finance Company Limited. In support of the said submissions, learned counsel for the petitioner has referred to the Annexure 1, Annexure I to the bail application, which is the surrender letter given by said Ranjit Kumar Gupta. Learned counsel for the petitioner has also submitted that the informant Sumit Kumar Shah had made a wrong statement in the FIR regarding his ignorance of any finance or hypothecation with regard to the seized vehicle, as in the deed of agreement entered into between Ranjit Kumar Gupta and Sumit Kumar Shah on 4th of May 2023. There was a clear mention regarding loan amount of rupees 3 lakh to the finance company, which was outstanding on the date when the said agreement was executed. Learned counsel for the petitioner has also submitted that after surrender of the said truck by Ranjit Kumar Gupta, it was kept in
Chobe parking.
Chobe parking. Where is Chobe parking?
At Tinchukia, inventory report, Your Lordship, Annexure.
Chobe
Annexure
parking
J.
in Fukia. And there was no element of any, there are no ingredient of offense of section 379 in the instant case. It is also submitted by learned counsel for the petitioner that the petitioners shall cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary, hence call for the case diary, fixing 6.5 for case diary. However, in the meanwhile, considering the aforementioned submissions made by considering the submissions made by learned counsel for the petitioner, the above named petitioners are hereby directed to appear before the investigating officer of the Makum PS case number 5/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, in the event of the arrest of the aforementioned petitioners, the above named petitioners in Makum PS case number 5/24, they shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2, fixing 654.
Item number 15 is same. The petitioners are current branch manager and petitioner number 2 is a senior collection executive. Same out of same FIR.
Case is same.
Same FIR, same. But the petitioners are in this case branch manager officials, branch manager and the collection executive officials here.
Same order.
Same
order. Name of the petitioners would be different.
Name and designation.
Name and designation is different. Lordship.
May it please your lordship. Lordship, this is a 438 bail application lordship. FIR lordship will find on page 11 lordship. I am the FIR name accused number 2 lordship. What happened in this case lordship? I am the owner of a vehicle lordship. My vehicle lordship, what happened? My vehicle was hired by the accused number 1 lordship. He is the co-villager of he is co-villager lordship. He asked me to come with his vehicle lordship to drop one person at Guwahati lordship. Accordingly, I went there lordship. I found their lordship, no patient was there lordship. Then I returned back lordship. On the next day, I come to know there's the person who is the lordship accused number 1. He was arrested lordship. In the forwarding report of this accused lordship, he confessed that he is involved in this case lordship. He has not.
So what is the allegation?
Allegation that is on page 11 lordship. May I read the allegation lordship?
Yes.
It is respectfully submitted that I have the honor to inform you that tonight at about 2 a.m. while I was sleeping in my house, one Rakibul Ali, Disha spice shopkeeper told me over phone that the accused person are looting my clothes shop situated at near New Market. Immediately, I went to the shop and found that they have dig a hole beneath the southern side tin wall of my shop with a dagger, crowbar, etc. The valuable.
What is your name?
My name is Sonavar Ali lordship.
Accusation is against Rakibul.
Lordship. No, that person lordship informed me.
Okay.
That person informed me lordship. In the meantime,
who are also digging.
No, lordship. I am the owner of the vehicle lordship, vehicle document lordship.
But let us go first. Allegation.
Yes, lordship.
Allegation is that you are also looting.
Digging.
In the meantime, I tried to call the nearby shopkeeper and the accused person tried to kill me with the deadly weapon. I raised hue and cry. Then the accused person come to know about the presence of the nearby people. So try to flee away. And the accused number 2, 3, 4 fled away on a 4-wheeler Maruti vehicle having no number plate. The accused number 1 was caught by the people. I informed to Mukalma police station. Then the police came and taken the custody of the accused number 1 along with the covered lordship. Now come to the forwarding report on page 16 lordship. The accused number 1 was arrested lordship. Ground of arrest lordship. He has said he confessed his guilt, but he has not stated lordship other people say other accused involvement lordship. Neither lordship the investigation officer sought for arrest of the rest of the accused person lordship.
Then
Now,
why are you apprehending?
why apprehended? Because of lordship. I have stated in my paragraph lordship 4 in page 5 lordship. They call this accused number 1 called me to went there to drop a passenger, drop a patient from to Guwahati from that Tenchukuna lordship. That lordship I went.
Story is not
Not
visible.
So
Lordship,
let the city be there.
I have the vehicle lordship. The person who have a Swift vehicle lordship just purchased few days ago lordship. He would not involved in such type of activities lordship. Since that accused number 1 is my co-villager lordship. He called me at midnight lordship for emergency call lordship. I went there lordship. When I found that lordship, it is not that lordship. I returned back lordship. That is my statement lordship.
You have not seen the first, first informant.
No, I have not seen that. I have seen.
But first informant has stated in FIR that he had.
They subsequently lordship. They have subsequently collected the name lordship. The person who has arrested lordship, he has not implicated me in the forwarding report lordship. He has not whispered about the name of this petitioner lordship. That vehicle document lordship I have annexed from 17 onwards lordship. The person having
the CDB there lordship.
Case very good.
Lordship, kindly allow me to record my statement because lordship, I have an owner of a vehicle lordship. Why should I lordship involve all such activities lordship when I have a costly vehicle of Swift vehicle lordship? It's not lordship. He was mislead me lordship. That's why I went there and I returned back lordship. I have stated in my paragraph 4 in page 5 lordship. Why should I go there, lordship? No. Because he is the co-villager, lordship. He asked me an emergency call, lordship.
19th of April, lordship.
In the meantime, I may be protected, lordship. Since
19 April. 18 opening day.
Which police station?
Is from Mukalma.
On 10th.
10th, lordship. 10th.
Heard Mr. B. Chaudhary, Learned Counsel for the petitioner. Also heard Ms. A. Begum, Learned Additional Public Prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. for consideration of the instant bail application. Hence, call for the case diary, fixing 10/4 for case diary.
Highly obliged.
Charge sheet.
Yes, Lordship, charging with protected.
Charge sheet and Lordship, 302 is there, Lordship.
Lordship, I be protected before I file my petition.
302 is there.
I am the owner of the vehicle. Lordship.
You are, it is a charge sheeted case.
Charge sheet, Lordship.
Then where is the apprehension?
Prevention, Lordship, police is searching for me, Lordship. I was the owner of the vehicle, Lordship.
Why police is searching you after filing of charge sheet? Whether NBWA has been issued against you?
Yes, Lordship.
Charge sheet has been laid against you also.
Yes, Lordship, page 18, Lordship, on the basis of the statements of the other accused person.
What was the allegation against you?
Allegation of it, Lordship.
You are the owner of the vehicle.
Yes, Lordship. FIR is on
Who
page.
has been killed? Who has been killed? 302 is there.
Yes. Two villagers has been killed, Lordship. They were the driver and there was another person, Lordship. All the person have been forwarded, Lordship. And they've already been released from the Lordship. Now, Lordship, the accusation is that I was the owner of the vehicle. That is the Lordship. But we do not appear before the court till and I may be protected, Lordship.
Did fix it? It did fix.
No, the charge sheet has been laid. Court has issued summons or processes against you.
Yes, Lordship.
You have received summons or warrant. What is the status?
Someone does a warrant paper. Someone does. Then he have received the summon. He will appear before the court below.
Then you appear before the court. Then why have you come to this court? You are not prepared.
Yes, that information is not been communicated, Lordship, as received.
No, I want to understand what is the apprehension of your being arrested? You have approached this court under 438.
Yes,
You are not yet arrested.
Yes.
You have received summons from the court.
No, Lordship, fix a date. I'll be.
You come.
Then you come prepared, Lordship. Let it be on 10th.
When do you want it? 10th.
Okay.
On request of learned counsel for the petitioner, let this matter be listed again on 10th of April. Come prepared.
Identity.
May it please your Lordship, 438 application, Lordship. FIR is at page 17, Lordship. May I read the FIR? The allegation in the FIR is that, Lordship, the petitioner, who happens to be a retired headmaster of a school, Lordship, he forged certain document of his colleague, Lordship, at the time of appointment. Altogether, there are 3 accused persons, Lordship. All of them are assistant teacher. 2 of them are assistant teacher, and 1 of them are headmaster, Lordship. The present petitioner is the headmaster, Lordship. The Lordship relevant portion is at page number 2, Lordship. Can you have a look?
Page number?
2 of the FIR, 18. Page number 18, paragraph 3.
Yes. Yes.
I have asked and inquired about the matter to Rafiqul Islam on 14/11/2022, and he replied that the Sahabuddin Ahmed, the then headmaster, has brought the mark sheet and certificate from Nogao College by making forgery. Again, he told that one Abul Kasam at present
What
working.
is your name?
My name is Sahabuddin, Lordship.
Shahabuddin.
Lordship. Lordship, this is a FIR lodged on 2021, Lordship. 2021, this FIR has been lodged, Lordship. As on that, nothing has been done, Lordship. Now, Lordship, the police has served notice under section 41, Lordship, without any rhyme and reason, Lordship.
You appear before
41.
Lordship,
41 notices.
yes, yes, I'll appear, Lordship. Even then, Lordship, I may be protected, Lordship. Similarly situated person, Lordship.
When is the date fixed for?
Lordship, on that day, Lordship, as because I was not well, Lordship. I was
You have defaulted 41.
41.
41 default date.
Lordship. Page number 24, Lordship. On 1st of April, Lordship. On 1st of April, Lordship.
You have not appeared.
I was not well, Lordship, therefore I didn't appear, Lordship, as because doctor advised me to take medical treatment in GMC, Lordship. I was
Where
suffering.
is? Okay, okay.
That
Huh?
is why, Lordship.
Oh, Mr. M. Halloy, learned counsel for the petitioner. Also Miss A. Begum, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Sahabuddin Ahmed, who is apprehending his arrest in connection with Moirabari PS case number 390/2021 under section 120B/420/468/471 of the Indian Penal Code. Learned counsel for the the gist of accusation in this case is that on, where is the FIR?
FIR is a page, Lordship, 17, Lordship.
That one Muhammad Safiruddin had lodged an complaint to the Chief Minister of the state of Assam
Same vigilance.
through the Chief Secretary to the government of Assam, inter alia, alleging that the present petitioner, along with two others, have been indulging in forgery and issuing forged mark sheet and certificate from. Where do you work?
Lordship, I retired, Lordship,
From?
from that school, Lordship. Haja Faita and ME school, Lordship. The informant is the headmaster and all the accused in this case, they are the employee of that school only, Lordship.
Stop.
I retired, Lordship.
The said complaint was forwarded to the officer in charge of Moirabari police station and the Moirabari PS case number 390/21 was registered. Learned counsel for the petitioner has submitted that the FIR was lodged in the year 2021, and for all these years, nothing was done. However, the petitioner had received a notice under section 41A from the SI of police, from one M. Devi, SI of police of Moirabari PS, directing the petitioner to appear before the police station, before the investigating officer on 1st of April 2024. Learned counsel for the petitioner has submitted that why you defaulted?
Lordship, I was ill, Lordship.
That the petitioner defaulted in appearing before the investigating officer as he was ill. And now he apprehends that if he appears now, he may be arrested in this case. Learned additional public prosecutor submits that perusal of the case diary would be necessary. Stop. Hence call for the case diary.
8.
Fixing 8-5 for
8-5.
case diary. However, in the meanwhile, as 41A notice has been issued to the petitioner, and as the matter is an old matter of year 2021, the petitioner is hereby directed to appear before the investigating officer of Moirabari PS case number 390/2021 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest, the above named, in the event of his arrest in connection with Moirabari PS case number 390/2021, the above named petitioner shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Fix this case again on 8th of May.
Hello.
Yeah, please. With regard to item number 28, my lord, today's.
Yes.
My lord, this matter may be taken up before lordship goes for this series, my lord. So this series is, lordship is going to take up at 2:30. I just pray by 28.
Don't know whether we, because there are other matters also. Yes. Okay, okay. Haritamat.
Item 69. May it please, Your Lordship. Petitioner applicant before Lordship for a modification and correction of the order dated, my lord, page 34, my lord. My lord, in this case, my lord, 6 petitioner before Lordship, before the Honorable Court. And my lord, Honorable Court, my lord, please may kindly see page 35, my lord. Third line, my lord. In respect of the present case, out of 6 petitioners, petitioner number 4 and 5 and 6 have already arrested. Actually, my lord, 6 was not arrested, matter. If Honorable Court permit me, first of all, your lordship interim order, my lord. Page 31, my lord. Page 31. My lord, interim order, page 32, my lord. Page 32, my lord. May I read this, my lord? Interim order, my lord.
Yes.
Page 32, may I read, my lord? By this previous bail application under 438 CRT, the petitioner, namely so-and-so, 6 petitioners, Deepraj Ramal, have sought for previous bail in the event of their arrest in connection with so-and-so, heart so-and-so, also so-and-so. Next, it has been submitted that the bail application has not been pressed as regards the petitioner number 4 and 5. For Sri Bikram Rimal and Sri Vibhuti Rimal, as they have already been arrested. But my lord, in final or and next page, page 33, considering the all entity of the matter till then, petitioner number 1, 2, 3, and 6. 6 is the applicant, my lord. Deepraj Rimal are allowed to go on interim periods bail in furnishing bail bond ₹20,000 each, with one surety like amount, so it's just.
Now, what correction you are seeking?
My correction is that, my lord, petition number 6 was not arrested, but wrongly, inadvertently written, and petitioner number 6 has been arrested, my lord, in page 35, my lord.
Okay.
My lord, that is my paid before inadvertently, my lord. After passing the interim order, my lord, we are Honorable Court given a condition to appear.
Now, what was the ultimate relief which was granted?
My lord, ultimately, my lord, already, my lord, interim bail granted so and so 12/7/2000 is hereby made absolute.
Mr. What is your name?
My name is Niran Bora, my lord.
Heard Mr. N. Bora, learned counsel for the petitioner. Also heard Mr. R.J. Bora, learned additional public prosecutor. This interlocutory application has been filed by modification of order dated 2/8/2021 passed by this court. in AB case number 1873/2021 on 2/8 modification of order dated 2/8/86, 2/8/2021. Stop. Learned counsel for the petitioner has submitted that inadvertently it has been mentioned in paragraph number 3 of the said order that petitioner number 4, 5, and 6 have already been arrested. However, in fact, only petitioner number 4 and 5 were arrested, and 6 was allowed to go on interim bail by order dated 12/7. 2021. Stop. I have perused the case record. On perusal of the materials available on record, apparently it appears that the mention of petitioner number 6 in line number 7 of the order dated 2/8/2021 has been made erroneously, as apparently he was not arrested on that day. In view of above, the order dated 2/8/2021 is hereby modified as same as same appears to be inadvertent typographical mistake. The order dated 2/8/2021 is hereby modified to the extent that the in line number 7 of the said order, the mention of petitioner number shall not be read, and same shall be treated to be deleted.
My lord.
Will it suffice?
My lord, and my lord, my lord, petitioner paying for the bail of my lord 1, 2, 3, and 6, my lord. That may be clarified, my lord.
And the order dated 2/8/2021 shall be applicable in respect of petitioner number
1, 2,
1,
3,
2, 3,
and 6.
and 6.
Right.
With above observation, this interlocutory application is hereby disposed of.
Matsu.
52 April. Update করছিলাম এখানে। What? The motion to join.
Yes.
The appellant was convicted under section 18 of POCSO Act for 2.5 years. So is named accused in the FIR. However, after investigation, my lord, as there was no material against him, there was no charge sheet against him. That means he was not sent up for trial. Now, on 25/1/2024, I filed an application for Jimma of the truck, and that was, my lord, allowed. I went to the police station to get back the vehicle after completion of the formalities. And the IO, my lord, most illegally took me in the custody, my lord, on 3/2/2024. Then, my lord, I filed an application before the special judge. Now, he has rejected, saying that case diary is required. Now, my lord, subsequently what he did, special judge beyond his jurisdiction, my lord, he has instructed that the IO should be allowed to take evidence of the two witnesses. Now, your
Evidence
lordship,
of two witnesses.
Yes. Now your
Charge
lordship
sheet has already been laid.
already been laid.
Further investigation,
Now, further investigation, as your lordship is aware, my lord is 79 appeals court has said that if you want to go for further investigation, you must take leave of the court. Then, my lord, in 2014 also, the Honorable Supreme Court has said, my lord, if you want to revise that order, only two courts can do it, that is by the session court or by the Honorable High Court. Now, if you want to revise, my lord, that will you have to take recourse to 398. Now, in 398, my lord, if you want to exercise that power,
390.
398 provisional power.
Okay.
Now, the court can make an inquiry, and in that inquiry, my lord, the court at best, my lord, the power, police has the power to go for further investigation, but there are certain formalities you have to complete. In 398, court has said that if you, after making an inquiry, if there is something, you'll have to convince that there is something. In that case, since he was discharged, my lord, he gets a right. So therefore, you will have to give a show cause notice. Then after that only you can do it. My lord, I will take your lordship to the orders passed. Your lordship may come to my lord, page first order is at page.
Now you are behind the bars.
Yes,
You are behind the bar.
it's totally an illegal detention, my lord. I will take your lordship to those judgment, but I will take you the facts first. Your lordship may kindly see the.
You are ready.
Well, lordship, today I'm not ready, lordship. I'll have to go to
My
the.
lord, let me finish.
Let
because
the date.
the
may be
public
fixed, lordship.
prosecutor will never get ready because these are the things the
No, no.
question law.
No, lordship, today there is, I have not been taken.
Today actually we are
From morning onwards, I was here,
time
lordship.
constraint is there. So
No.
because you
I'm
the
conscious
question
of
you
that.
have you are raising will take time.
My lord, the
The
question
issue
of
is-
law, question of law is very simple, my lord. I'll just take 10 minutes time. Your lordship kindly give me that time. I'll satisfy your lordship. First, I will take you the relevant facts, my lord. Now, when he has been discharged,
The copy, lordship, scan copy.
these are all it has come, I think. Scan
No,
copy.
scan copy is there, but
No, let
lordship,
her get prepared.
let me get
We'll
prepared, lordship.
take it up on Monday or Tuesday.
Monday, Tuesday, lordship, Tuesday.
Monday I'll not be here, but then my lord, your lordship kindly see the appeals court decision to that extent. Whether after the filing
Now,
of the charge sheet,
in this case, what has happened after filing of the charge sheet?
they have arrested me, my lord. Under what provision of law?
There is no further investigation.
No further investigation. Well, the court has allowed, special judge has asked the CGM to take evidence of these two witnesses. What is the power of special judge? He is oblivious of the legal position. Well,
Where
can
is
he
the order?
pass such order?
You have challenged that order.
Well, that order is before lordship. That's the reason, my lord, I want to take your lordship to that.
Which order?
Yes,
At page?
at page, my lord, first your lordship come to page 46.
No, let us first go to that
Yes,
order which is
Right.
dating.
lordship may come to page 52. Accused, has your lordship got that?
Yes.
Accused petitioner is represented by learned counsel in the bail petition being petitioner so and so, so and so. Learned counsel for the defense stated that in the charge sheet submitted on 30/11/2023, accused was shown not sent up. But the learned public prosecutor pointed out that in the additional report submitted, further material has come out, which shows the involvement of accused in connection with this case. I have perused the additional report and the SCD and also on perusing the statement of the witnesses. Namely,
Additional
Rajesh-
report has to be after further investigation. That
Now, my lord, this is when it has happened. Your lordship, that's the reason. Your lordship kindly see the first order, the bail order, what the court has said at page 47.
now is it necessary for the IO to take leave of the court for?
No, not at all, my lord.
No, leave of the court.
He has to, my lord, file an application before the court that he want to go for further investigation. Now, where is that, my lord?
No,
For that, my
where is
lord,
that law?
yes, that's the reason, my lord, I said I will take your lordship to certain decision which will make the thing very clear. My lord, 1979 2 SCC, page 322, para 21.
What it says?
Para 21, my lord, as observed by us earlier, there is no provision in the CRPC so and so which expressly or by necessary implication barred the right of the police to further investigate after cognizance of the case had been taken by the magistrate. Neither section 173 nor section 190 lead us to hold that the power of the police to further investigate was exhausted by the magistrate taking cognizance of the offence. Practice, convenience, and preponderance of authority permitted repeated investigation on discovery of fresh facts. In our view, notwithstanding that a magistrate had taken cognizance of the offence upon a police report submitted under section 173, the right of the police to further investigate was not exhausted, and the police could exercise such right as often as necessary when fresh information came to light. Where the police now, this is the important line, my lord, where the police desired to make a further investigation, the police could express their regard and respect for the court by seeking its formal permission to make further investigation. Now, on the last occasion, my lord, when I addressed the court on that point, the lordship wanted to know what is there in the, my lord, the case diary. Now, because of that case diary was called, let the learned PP show from the record that that application was before the court. On the contrary,
now is it mandatory?
it's a mandatory, my lord. Now, take your lordship to 2014 also, the further improvement have been made.
What it says?
Yes, the 2014.
It only says that police could express their respect and regard to
Exactly,
court.
my lord. Now,
It,
when?
it says it is not mandatory.
My lord,
Indirectly,
now this question will come. Now here, my lord, the court is allowed to manufacture a case for further investigation. My bail application rejected on 5-2. They have taken they have come up for the special judge for taking a, my lord, permission that two witnesses, he should direct the CGM
No.
to take the evidence.
in 2014, show me the
Yes, yes.
provision.
2014, your lordship, kindly see at paragraph 112. However, there is a great difference with
No,
regard
come
to.
directly to the point. Where court is observing that it is
Yes.
that leave has to be taken.
No, leave is there in the 79 Supreme Court. The
But
Supreme
that
Court
is
has
not
said-
very clear. It says that it would be proper, it is normally proper for the investigating officer to take leave. It is a question of propriety only. But if such leave is not taken, it does not become illegal.
My
That
lord,
is my understanding.
Yes, now, therefore, my lord, it's up to your lordships if that decision of the appeals court, if it is to be taken as, my lord.
Lordship, let it come on Tuesday, Lordship. I'll
Let
go
her
through.
get ready.
My lord, this is a, you have, because your lordship, why I am saying so, your lordship kindly read the order dated 5/2/2024. Whether the court has exceeded its jurisdiction or not.
5-2.
5 at page 47. Seen the, as your lordship got that?
Yes.
47. Now I'll take to your lordship, later on. Seen the prayer made by the inspector officer in charge, Nagar Police Station, for recording the statement of the accused persons, it should have been witnessed, my lord. So casual approach, namely Rajesh Urang and Shanjit Ravidas under section 164 CRPC in connection with so and so. Peruse the relevant papers. The learned Chief Judicial Magistrate Karimganj shall do the needful recording the statement
Now,
of aforesaid accused persons under section 164.
If this order is beyond if it is beyond jurisdiction.
Yes.
Then you have to challenge this order.
My lord, the question would be, if I am after discharging, my lord, there is no charge sheet against me. The law is very clear. If you want to, my lord,
After
implicate me once again.
You were originally the accused. You were named in the FIR.
Named accused in the FIR.
Okay.
After investigation, my lord, I have not been charge sheeted. I have not been sent for trial. Now, therefore, I have been discharged. Now, if you want to implicate once again, there must be fresh facts, my lord. I mean, further information must be there. Where is that further information? Then now they want to manufacture a case, and the learned judge is helping to that. He is saying he is permitting CGM. Where is the jurisdiction to do that? First thing he will have to see whether discharge gives him a right. If it gives him a right, my lord, Supreme Court has said he will have to give me a show cause. Now, all these things are not complied at all. And is it
But
not a my lord,
can-
illegal detention?
Whether in these questions we can go into in a bail application.
My lord, when something is done quite illegally, I'm in the illegal detention. My lord, your lordship, I think it is required to see all that. It's a case of bail, my lord, I'm illegal in the jail.
Not illegally. Their case is that during further investigation, some material was
No,
found
what
on.
is materials, my lord? I am asking that.
Michael,
Material is that they want a leave of the court to take evidence of the two witnesses. Now, can you, if you can say, this is the fresh
There is
fact.
no material.
No material at all.
Okay, let her go through the case.
Tuesday, lordship, Tuesday,
We'll take it up on Tuesday.
Tuesday.
My lord, at the
We'll-
last end of the day, if your lordship can,
Okay, we'll keep
Really,
it.
my availability on the Monday, I'm not sure I'll be here or
No,
not.
on Tuesday we'll take it up.
Tuesday.
Tuesday or Wednesday, whenever,
Your lordship, give us preference to that, my lord,
when.
on Tuesday, my lord,
Tuesday.
as a part-heard matter.
Okay. Heard Mr. S. Dr. Learned, Senior Counsel Assistant of Mr. S. Dr. Learned Counsel for the petitioner. Also heard Miss A. Begum, Learned Additional Public Prosecutor, who prays for some
51 motion.
more time to make her reply submission. The prayer is allowed. Let this matter be listed on 9th of April as part of.
Yes, much obliged.
Item 51. 51.
With pleasure, lordship. 438 application, my lord. The other page 12. My lord, the apparently background is a piece of land, my lord, that has been sold twice. First to the petitioner, the bail applicant, and second to another one. And that's how the dispute arose. Your lordship may
No.
kindly go through the short ejaha, my
This
lord.
is a complaint.
No, actually, what happened, my lord, he explains at the end of the first paragraph, my lord, finding no alternative, we submitted an ejaha in Simla police station, but no importance being given by such police station. We have come to the honorable court seeking justice. It is therefore explained, and this on transfer, possibly, my lord, there was an order from the court, my lord, from the subjudicial.
On the
judicial
basis
magistrate.
of this complaint and FIR was.
FIR was raised.
not. Okay.
That order we didn't get, my lord. But apparently that is
What
the
is
fact.
the
my lord.
allegation against you?
My lord, allegation, my lord, that I had removed the tin sheets, your lordship. May I read, while
What
Surajit
is your
Das,
name?
I am Surajit Das, my lord.
Surajit Das.
Surajit Das, son of Navajyoti Das, coming from his workplace at Bongaigaon in CISF uniform with government staff in an inebriated state and his goons demolished the said house and picked up the tin sheets in a vehicle. When we objected, Surajit Das came to hit us with his government staff and shouted at us using bad words, finding no alternative. So this is the allegation, my lord. There was no assault, apparently, my lord. And I am a constable, CIS, I am from the discipline force, my lord. And that piece of land was sold to me earlier, which I have annexed, man. I have paid 8.5 lakhs, man. That is at page 20. And thereafter, my lord, it was sold again. Same land, my lord. There is only difference of 2 lecha, but that number, pata number same.
No, 426.
No, only one 380 is there, my lord, and I didn't take it. That police arrived and police took away the tin sheets, my lord, lying in Simla police station. It's a chali. Tin chali was
raised by. So that was,
The case is registered under section.
my lord, the non-bailable section of 447, 426, 380 and 506.
What is 426?
My lord,
426?
no, that will be Michi also. Michi. 447 is trespass.
Punishment for mischief.
Michi, my lord.
Mischief.
What is 426?
Punishment for
Three
mischief.
months, my lord.
3 months.
He said 380 mal how do you
Okay. Heard Mr. B.D. Goswami, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, who is apprehending his arrest in connection with Simla PS case number 17/2024 under section 447/426/380/506 of the Indian Penal Code. What is your submission regarding allegation that theft of
My lord,
thing-
that is the land that was sold to me, my lord. After receiving, my lord, the document shows
the
that
gist of
annexed to-
allegation, gist of acquisition?
I paid 8,26,000.
Okay, gist of accusation against the present petitioner is that on that one, she Ashut Kakoti had lodged an FIR, lodged a complaint before the Court of Chief Judicial Magistrate, Baksa, inter alia alleging that on 27/2/2024, the petitioner trespassed into the tin shed house situated over a plot of land covered by dark number 236 of periodic patta number 197 of Angulia village under
Angulia, my lord.
Angulia village under
Koklabari Moja,
Koklabari Moja.
Jala Revenue Circle.
It is alleged that the petitioner went there in an inebriated condition and picked up tin sheets in a vehicle and hit the informant, hit the complainant with lathi and used bad language. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR are not true. He has submitted that the land in question was for purchasing the land in question. There was an agreement for sale executed between the present petitioner and the first informant, and the petitioner had paid an amount of rupees
8,26,000.
8,26,000. It is also submitted that the petitioner is an employee of CISF,
Constable, posted in Bangladesh.
posted in Bongaigaon, and he shall cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary, hence call for the case diary. Fixing 2/5 for case diary. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as on the basis of annexures annexed along with this bail application, no, last one, annexure is required. Considering the submissions made by learned counsel for the petitioner. No, cut this one. The petitioner is directed to appear before the investigating officer of Simla PS case number 17/24 within 10 days from date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Simla PS case number 17/2024, the above named petitioner shall be allowed to go on interim bail of 30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. This matter again on 2nd of May, 3rd of May.
2nd of May.
3rd May.
3rd of May. March of the.
May it please your lordship, my lord. On last occasion, my lord, I never looked, it is not there. But I believe, my lord, if lordship goes for the documents available on record, my lord, it would not require the city, my lord. In last occasion, lordship was asked me to submit the lower court's order, my lord. That is that, my lord, the additional affidavit I have
You have
filed.
filed an additional affidavit.
Yes, I filed an additional. Now to refresh the memories, my lord, what I would like to place before your lordship, my lord, the FIR which says, my lord, it's an admitted position by the informant that they took money from me. That is at page 10, my lord. And the order rejecting the bail prayer, my lord, in lower court, that is at page 39 of the additional affidavit.
Yes.
Has your lordship got it, man? Accused person Mohammed Anwar Hussain produced before this court on being arrested in connection offense under sections 387, 420, 506 IPC read with section 7C2 of Assam Moneylenders Act. This 7C2 is the bailable offense, my lord. Seen the accused forwarding letter along with other relevant documents, the accused person on being asked stated that he has already engaged advocate for his defense. The accused person stated that
charges under section 7C2 as well as 387, 425.
420, my lord, there is not at all any ingredients. Lordship can, if lordship goes to the FIR, my lord, it is only, even if, my lord, that day also I submitted, my lord, if lordship remembers, my lord, that even if the whole FIR is stated to be true, my lord, then also it is a case below 7 years. So 41A notice, Ernest Kumar, Satyendra Kumar, until nothing was followed, my lord. Nothing was followed. Police cannot arrest on these cases. Well, it's a bounden duty of the courts of the country to follow the instructions and the verdict of the Honorable Supreme Court.
Where have you stated that 41A has not been followed? You have stated in your petition.
It's a question of fact, question of law, my lord.
No, it is a question of fact. Whether
My lord, he was lifted from house.
Listen to me. Whether the notice has been issued or not is a question of fact. The requirement of issuance of notice is a question of law.
I understand, my lord. I bow down to your lordship, my lord. Now, my respectful submission, kindly see it from the materials available on record.
Have you pleaded that 41A notice has not been issued? Otherwise, we have to peruse the case diary to see whether.
I understand, my lord. I understand, my lord. What your lordship may be pleased to see into this, that even if the entire, my lord, FIR is presumed to be true for this moment for granting the bail, my lord, for the purpose of granting the bail, then also there is no offense, my lord. That is my respectful submission. Kindly appreciate once, just for a while, my lord, this person is kept behind the bars, and if somebody's whims and fancy, my life and liberty cannot be curtailed. Kindly appreciate. They said it pays 10, my lord.
No. Okay. Facts have to be there in the record.
Yes, that is on from, I am reading from the records. This is a registered FIR. They said, my lord, they have taken money from me.
The allegation against you is under 387 also.
Yes, that is, I am replying to this. Taking money in interest is an offense under section, under the Assam Moneylenders Act, which is bailable, that I have already submitted a lordship. Now, whether I have forced them to sign a document to sell a land.
Whether there was extortion on you.
Yes. Kindly see next, my lord. Page 16, Annex 3. this is a sale permission signed by all the brothers of the landlords. And it was granted in 22 February 2024. FIR was filed on 28th of March 2024. Will your lordship believe this? Does it inspire confidence of this court, my lord, that there is extortion, putting them in fear, them under fear to extort money? This sale permission is a government document, my lord. And sale permission was granted on 22nd February. It was initiated 1 month ago, or maybe more than that. Nowadays, my lord, sale permission of a land is granted only when, my lord, when they took photographs on the spot, along with the mandal, buyer, seller, everybody has to take a photograph on the spot, giving Google location. That photographs along with the affidavit has to be submitted before the deputy commissioner for granting of the sale permission. This was, after following all these formalities, this was granted on 22nd February. Then the attempt was made to execute the sale deed on 27 March 2024. More than a month later. Some of them have executed 3% out of those 5 executants. 3% have signed a document. 2 have gone away. And going at home, they filed this FIR saying that there is an extortion. I have put them in fear for extorting money. On the other hand, in FIR, they have accepted, they have admitted that they have taken money from me. Kindly appreciate, my lord. Only somebody's fancy and whims, my lord.
Yes, Mr.
Lordship, if I look into the FIR, there are some lines, Lordship, where committing of suicide, while they are forced to that extent, Lordship, and they have also stated that now the accused has come to occupy a plot of land by demanding that he would get 29.
What is the punishment for 387 maximum punishment?
7 years, my lord. Extend to 7 years.
Okay.
They are also forced to sign, Lordship. And if you look into the FIR, Lordship.
Even then, there is no 387. My respectful submission is this: presume it to be, for the purpose of granting this bail, presume it to be true that the whole allegation level in the FIR is correct. Even then, 387 is below 7 years. It can extend to 7 years.
CD is not, Lordship. CD, Lordship.
Why CD? CD will,
Here's the Lordship.
but the CD will include the statement of the informants. 130, 161.
If 41A notice is not given, I am inclined to grant you bail. But whether 41A notice has been given or not, that
My lord, also, my lord, I will see to your lordship. My lord, the FIR was filed on 28 February.
no, not on presentation.
28, no, I'm showing you the records. FIR was filed on 28 March. I was arrested on 29/3. And
Next day.
And I was produced before the court on 30th March, the next day. And the bail was rejected on 30th March. So I am behind the bars from 29 March. What is the scope of 41A notice? These things are on record, my lord.
No, you should have mentioned it in the heard Mr. A. Chamon, learned counsel for the petitioner. Also heard Mr. A. K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Anwar Hussain, who has been detained behind the bars since 29/3/2024 in connection with bail short PS case number 45/2024. The counsel for the petitioner has submitted that the bail short PS case number 45/2024 was registered on the basis of an FIR filed by the Korobi Burman Srimati Korobi Burman Talukdar before the officer in charge of Belsar Police Station, inter alia, alleging that the that the husband of the informant was forced to hand over land documents by signing stamp paper to the present petitioner, and they have also threatened that, and the petitioner has also threatened that they would kill the family members of the first informant. On this, it is also mentioned in the FIR that the husband of the informant had earlier borrowed an amount of rupees 10 lakhs from the present petitioner in the year 2020, and the petition, and it has been alleged that on failure of the payment of interest by the husband of the petitioner, husband of the informant to the petitioner used to threaten the husband of the informant as well as her brother-in-law. And it is also alleged that the present petitioner has illegally tried to occupy the plot of land belonging to the informant, asking that unless an amount of rupees 20 lakh is paid, 29 lakh is paid by the the land has to be transferred. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR are not true. It is also submitted that there was a where is the agreement?
Agreement Milord is that the sale permission at page 16 Milord, and the agreement they were supposed to sign at page 23. The type copy and the photocopy is page 25. Three of them have signed this agreement.
This is agreement to sell or sale deed.
Sale deed, Milord.
Sale deed. That a sale deed was executed between whom?
Between the present petitioner and three of the landlords, Milord. Jyotish Talukdar, Gitima Talukdar, and Jivaneshwar Talukdar.
What is the relationship between?
Jyotish Talukdar, Jivaneshwar Talukdar are the brothers.
No, relationship with the first informant.
Informant is one of the wife of informant is the wife of Milord, one of the brothers.
Name?
His name is, the husband name is Janakeshwar Talukdar.
Jogeshwar.
Janakeshwar. Jugeshwar Talukdar, he died, Milord. His wife also given a money receipt. Her name is Gitima Talukdar. She signed on the behalf of her husband. That your lordship can see at page 24. Jyotish Talukdar, Gitima Talukdar, and Jivaneshwar Talukdar. There were 5 persons. Lordship can see at the sale permission at page Milord 16.
Counsel for the petitioner has also submitted that the petitioner had paid an amount of rupees 30 lakhs to whom you have paid this amount?
This was paid to Gitima Talukdar.
By?
Pardon, Milord?
Who had paid it?
Pardon, Milord?
Who had paid it?
This Anwar Hussain, Milord, the petitioner.
The petitioner has
Yes.
paid an amount of rupees 30 lakhs
Yes.
to one Gitima Talukdar who is the wife of Yogeshwar Talukdar, who is the co-pattadar of the land in question. It is also submitted by learned counsel for the petitioner that on 22/2/2024, the sale permission was
Granted
granted to the
by the district commissioner and all right.
to the pattadars of the said land, including the husband of the first informant by the Deputy Commissioner Nalbari. It is also submitted by learned counsel for the petitioner that the offense under section 7C2 of the Assam Moneylenders Act is bailable offense. And as regards other offenses, the maximum punishment prescribed under law is not more than 7 years.
Yes.
However, no notice under section 41C of the Code of Criminal Procedure was issued to the present petitioner. And on the very next day of the lodging of FIR, he was arrested. Learned additional public prosecutor has submitted that though case diary was called for, however, same has not arrived. And prays for some more time for producing the same. When can you produce?
On
After before.
no, my lord, can it
On
be
by
on
19th?
8? Can it be on 8th of April? My
No,
lord,
I'm
this
giving-
man is,
I'm giving you interim.
my lord.
24 lots. Sorry, lots. It's all.
Considering the
19.
sufficiency, considering the fact that the petitioner has been arrested on the, I am recording your submission.
My lord, my lord.
If it turns out to be false, you will face
No,
the
my lord.
consequence.
Yes, I will face the consequence.
The considering the submissions made by learned counsel for the petitioner that no notice under section 41A was issued to the present petitioner, also considering the fact that from the records, it appears that on the very next day, the next day of the lodging of FIR, the accused, the petitioner was arrested. It appears prima facie that there is violation of the mandate of issuing notice under section 41A of the CRPC, which is required to be verified only after perusal of the case diary. However, considering the mandate of the apex court in that any violation of section issuance of notice under section 41A would entitle the accused to go on bail. The present petitioner is allowed to go on interim bail till arrival of the case diary till arrival of the case diary. He shall be released on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Nalbari, with following conditions. Condition number 1 and 2. Let this matter be listed
29 April.
again on 29.
29 April. I'm obliged. I'm deeply obliged.
May I please your lordship? Well, this is a 439 application. Today I am behind the fire for
29 days.
29 days, my lord.
439.
He's in custody, my lord. Now, first of all, my lord,
I happens to be the superintendent of the central jail at
CD
the
is there.
city is there.
Case diary is there.
I happens to be the superintendent of the central jail, Dibrugarh.
You are superintendent of central jail,
Dibrugarh, yes.
or you are behind the
Yes,
bar?
my Lordship will find how I am behind the bar, my lord, and how the conspiracy is. The page 15 is the FIR, my lord, filed by me, my lord, first of all. Page 15.
Yes.
FIR against the possession of, has your lordship got it, madam?
Yes.
The FIR against the possession of unauthorized material, devices with NSA detinue of Central Jail Dibrugarh on 17/2/2024. That means on that night, I have found that these detainees are using these mobile phone, my lord, on my inspection, my lord. That you can see.
Okay.
So accordingly, I have filed on the next day, I have filed an FIR before the Dibrugarh
This
PS.
FIR
I have lodged, my lord.
15 is lodged by you.
Yes, my lord.
Okay.
That's
What was the allegation that
these detainees, they are inside the jail, they are using this keypad, TV remote attached to keypad, spy cam, etc.
but why have you allowed? Because you are the superintendent.
Yes, I have found them using, my lord.
Okay.
On the inspection, they
On-
are secretly using it. So I have lost an.
Thereafter you lodged at the FIR.
Yes.
Okay.
Because on my FIR, many person will be affected, my lord, because of my FIR now. Because on that day, the previous night, I found that on 17, they are using it. I have lost the FIR, first FIR. It's a matter of fact. And according to these all these are seized.
On which date you have lost the FIR?
On the 18th. On 17/9, I made the inspection. On 18 morning, I filed in FIR.
Okay.
Because I have made a search operation, madam, as per the FIR itself.
During inspection?
Yes, search operation, it was secret, found that they are using those devices, my lord.
Okay.
In the search operation, which was conducted, NSA detainees were so-and-so, with the help of anti-sabotage search team, detained so-and-so, Dibrugarh. So accordingly, I lost the FIR, which has been registered as Dibrugarh PS case number 64 of 2024, my lord, under section 353/143 IPC. So this is the case was registered under the 64, my lord. Now, thereafter, what happened, my lord? The second FIR for the same facts, page 18, my lord. Now, this is the Dibrugarh PS 84, my lord. Now, lordship, kindly, the first line is very important. I have honor to inform you that
who lost this FIR and some other police officer. Okay.
Yes, page 18, my lord. I have honor to inform you that in process of investigation, in connection with the Dibrugarh PS case number 64.
Lodged by you.
Lodged by me.
Okay.
On the same process, the investigation, it pertains to 10 NSA detainees kept in the Dibrugarh Central Jail, including chief of the pro Khalistan successionist group, Waris Punjab De, namely Amrit Pal Singh and his associates, various electronic items like Oppo mobile phone, Greenberry mobile phone, etc., were seized on being produced by jail authority, which were recovered from the NSA detainee, and it has come to the light, Nipenda, superintendent of jail, Dibrugarh Central Assam, in collusion of the other jail staff, provided these articles to be detainees in violation of the provision mentioned in Assam.
You are Nipendas.
I am Nipendas.
Okay.
So that means I have filed the FIR against me, madam. As we believe in the second FIR, I have filed the FIR, first FIR against me, myself, that I am allowing and I am using, they are using it, my lord. How they can investigate? If that be so, on my FIR itself, there is no bar. They can obviously arrest me on my FIR itself. If I am
Actually,
also
in-
being an
in-
informant
in
also.
your FIR only, you have to be arrested.
Yes, there's no bar at all. There's no bar if I am privy to the offense. If I have did the offense, definitely.
This is
can
the
be.
second FIR.
It is the second FIR and they have mentioned it.
A separate case was registered.
Separate cases registered on the basis of my FIR and on the basis of the same seizure. There's no separate seizure. On the basis of the first FIR, which has been seized by me, they lost the second FIR.
There appears to be procedural error.
Maybe one.
Me-
There's a reason
But
behind
there
it.
is no bar in
There's no bar at
arresting.
all. There's no bar. If I am always, if I did the same thing, I
If
have allowed
on-
them.
If on your FIR, it was ultimately found that you are the accused.
Yes.
There is no bar.
There's no bar at all.
Okay.
But the fact remains here, the whatever material I have seen on the 17th and I lost the 18th FIR. On that basis, they could have investigated and they could have arrested me. But the second FIR has been filed and seized the same material again. And this time allegation against me that I have allowed those detainees to secretly use those material. That is the case. And there's a delay also. There's a difference between the two gap. My lord, the first FIR I have lodged 18-2 and the second FIR 7-3. It is 7-3. 20 days after. Now, the allegation is that I have consciously abetted the successionist agenda of the pro-Khalistani outfit. Now, actually what happens, my lord, because of my first FIR, if the investigation is carried out, my statement and the other material, it will create problem for the many others, my lord. So it was the intention to put me behind the bar so that the other people who's actually abetted those people, who has given those articles secretly to those people, they will be.
But this is a bail application.
Yes. So that is the. Now, Lordship, kindly see page 90. Forwarding. So here, the case was registered in my case, my lord, under section 13, which is up to 7 years, my lord. UAPA, my lord. Punishment is provided up to 7 years.
Okay.
Now, admittedly, there is no notice to me. And grounds, Lordship will find page 20. That, has your Lordship got it, madam?
Yes.
Page 20. That, Your Honor, 41A CRPC has not been complied due to the following grounds. The case involved a serious threat to the security, sovereignty, and integrity of the nation, and the accused might abscond and help the other co-accused to abscond, madam. The other co-accused who is in the custody of them, how can I help him? If I allowed them to abscond, I could have done it long before. And I'll be in trouble because they are in my custody. I'm responsible. If I allowed them to go, absurd reason, my lord. They are already behind bar. They are in the custody. How can I allow them to abscond, my lord? They are in custody itself. If I allowed them to I cannot of my own allow them to flee from the custody, from the jail inside the cell, who is in the custody. And they are NSC detainee, my lord. And I have lost an FIR 20 days long back. This is the ground, my lord. And there is no reasoning at all, my lord. This now, these.
Now, on the second FIR, a separate police station case has been registered.
And that on when I have been arrested,
No,
admittedly
let me
41.
understand. On the first FIR, a PS case was registered.
63.
After 20 days,
The
a
second
second
FIR
FIR
registered.
was lodged and a separate case was registered.
Yes, my lord. Where I have been arrested without following the 41 notice, no notice has
And
been
both
served.
are parallelly being investigated.
Yes, my lord. Both are going on. Not been clubbed. Then in my
You are arrested in the second FIR.
second FIR. And its material has been seized on my FIR, on the basis of my FIR. They have again, they have made a prayer to the court to reseize those articles in the second FIR. The part of the case diary will be there, my lord. I have a copy that will also reflect in the case diary. They have made a prayer to the concerned, my lord, magistrate to reseize those articles, which as I have seen. Now, the lordship knows it, all the judgment, my lord, the Anes Kumar judgment and the Altir judgment. They're twofold, my lord. The first of all, while arresting without complying with 41, they have to give the grounds, first of all, and the reasons for his belief. Both are required. And the reasons for his belief, as lordship has found that, I'll allow them to abscond from the jail custody. Can it be a reason for not complying with the 41 man, who is already in the custody? And now, lordship kindly see the second fold, my lordship knows it, that the 41, yes, they may give a reason, but now it is the duty of the magistrate to find out whether these reasons are sufficient or not. He has to apply his own mind.
Before remanding.
Before remand. Now, what is that has been complied with? If that is not complied with, the Supreme Court has said, all lordship knows, he should be released on bail. Now, lordship kindly see the magistrate order on the first day itself, page 21. They have asked for 5 days custody. Page 22 is the relevant portion, my lord. The IO has submitted that the arrest of the accused person is necessary for the purpose of investigation. It is seen that IO has made a prayer in bona fide manner, and the reasons for seeking police remand mentioned in the case diary in accordance with the requirement of section 41B of section 41, there is concrete materials to substantiate the ground mentioned in the seeking police remand, hence the prayer of the IO is allowed. Where is his reason, my lord? That the reason given by the IO that they will abscond, and I will help him to abscond. He has simply, that is not the application of the mind which the Supreme Court has reiterated in every cases, my lord. He has to give his own reason, going by the case diary, that there is a material so that I can help them to abscond from the custody. Where I am the custodian, I am the superintendent, I'll be liable if they flee from the custody. And the same material, I am the person who has filed the FIR. Those material was not placed before the magistrate also.
Now in second FIR, whether the NSA detainees are also made co-accused?
No.
Or is it only against you?
Only against me, madam. Basically, it appears to be, madam. Because they are already in the custody.
So both the facts are different facts.
Different facts, but it is there. They have made it. If they are also accused, why they have not taken in the custody in the second FIR again? They could have been shown arrested in the second FIR, along with me.
What is the maximum punishment?
7 years, my lord.
13(1)(b)?
Yes.
7 years. 75 Prisons Act?
It's a bail, 6 months, bailable offense.
And 120(b) is there. Who are the other co-accused?
Those, my lord, the detainees, maybe.
Okay.
So, they have not arrested those detainees again, madam. If that be so, why they have not been shown arrested in this case, madam? if they do, they are also equally liable. 120B, I cannot go for 120B alone, and they are inside the custody. And the reasons is absolutely absurd reason, madam. That is not the idea of the Supreme Court for giving the custody of a person under 41A, madam. Only simple reasons will not do, madam. There is a sufficiency of materials all required. While be going by the application of the magistrate also should apply his mind, because the ground mentioned that I will allow them to abscond. How can I allow them to abscond from the prison, my lord? Can I allow them to abscond from the prison, my lord? And that ground, magistrate has found that there is a material sufficient that I will allow them to go in prison. That's right. Now, lordship knows, my lord, I don't just the paragraph 32 is the magistrate parts, my lord, of that Satyendra Kumar until judgment, my lord, paragraph 32. Only relevant portion, my lord, lordship can see paragraph 32.
The first FIR was registered under what provisions?
Under that was registered
140.
353, 143.
Yes. So your main plea is that with requirement of 41A
that is
was not complied.
Not complied with apparently, madam. They himself said that the 41 not followed. They have given a ground that I may allow them to abscond from the custody. And subsequently, my lord, they made a prayer before the trial court, my lord, to re-seize the material which I have seized, my lord. And the prayer was allowed accordingly. Admittedly, my lord. Those are the material which has already been seized by me. They wanted to re-seize in the second case. For the same cause of action, my lord. Same cause of action cannot be, there cannot be two FIRs for the same cause of action, my lord. That law is settled, my lord. There cannot be a second FIR. And I have been behind the bar for last 33 for the second FIR. And what about my FIR that I have initiated? There's no allegation that I have lodged a false FIR or fabricated FIR to shirk my responsibilities in 17 itself or 18 itself. To that effect, there is no investigation then. That the first FIR lodged by me just to divert the things. That's very important. Why in the second FIR, they have not come out with that I have intentionally filed a false FIR. And the magistrate, my lord, paragraph 32, just for my satisfaction, I am reading, my lord.
Yes.
Magistrate of Partner. We also expect courts to come down heavily on the officers expecting the arrest without the compliance of 41 and 41A. We express our hope and that the investigating authority would keep in mind the law laid down in the Anis Kumar and the discretion to be exercised on the touchstone of the presumption of the innocence and the safeguard provided under section 41. That here is the my question is the presumption of the innocence, my lord. Because of my first FIR, the article I have seized, that is the presumption of my innocence. That also lordship has while granting the custody, my lord, the magistrate has to look into that aspect also. But they have concealed that fact. My presumption of innocence, and it is apparent from the face of the record that I have filed the first FIR. On the basis of my first FIR, case has been registered, article been seized.
Yes.
So apart from lordship knows it, what is the until says that the futile ground or the ground which is apparently is missing here.
which is the requirement of 41, man. Simply just putting some ground will not do any magistrate. He just said that he is satisfied with the ground. Wherefrom his satisfaction has come out and his reasoning. And paragraph 21 says, 28 says, we only reiterate that the direction aforesaid ought to be complied with, that is with Anes Kumar's direction, with the letter and spirit by the investigating and the prosecuting agencies.
Okay. Okay. Yes, Mr. Das.
My lord. My lord, first thing, my lord, one thing I believe that, my lord, one thing should be brought to your lordship's notice. By order dated 33/2024, section 39 1B 2 and 3 has been added to the case. 39. That is under chapter 6 of the, my lord, Prevention of Unlawful Activity Prevention Act, my lord. Section 39 1B. My lord, I'll hand over the, my lord, entire case there to your lordship, because this is a, my lord, important case, my lord. So, my lord, rigor of 43D will apply. Now, my lord, coming to the submissions made by my learned friend, I submit. My learned friend submitted that he has lost an FIR against himself. That is the first FIR.
39(1)B.
39(1), my lord, English 1. We didn't forget.
What it says,
the-
39(1).
My lord, this is, my lord, UAPA. UAPA. UAPA Act.
No, you may read it.
My lord, this is an offense relating to support given to a terrorist organization.
Okay.
English A, my lord. A person commits the offense relating to support given to a terrorist organization who, with intention to further the activity of a terrorist organization, clause 1, invites support for the terrorist organization, and the support is not restricted to provide money or other property within the meaning of section 40, or B, who, with intention to further the activity of a terrorist organization, arranges, manages, or this is our section, my lord, or assists in arranging or managing a meeting which he knows is to support the terrorist organization. Subsection B is there, my lord. To further the activity of the terrorist organization, or to be addressed by a person who associates or professes to be associated with the terrorist organization, or who, well, this is not relevant for us. Now, subsection 2 provides for the punishment. A person who commits the offense relating to support given to a terrorist organization under subsection 1 shall be punishable with imprisonment for a term not exceeding 10 years, or with fine, or with both. Now, section 39 falls under chapter 6, and offenses enumerated under chapter 6, my lord.
43D is.
So for bail matter is concerned, my lord, rigor of section 43D will apply.
Okay.
Here will offense list, my lord, the section list 39 1B clause 2 and 3. To further the activity of the terrorist organization, and to be addressed by a person who associates and professes to be associated with the terrorist organization. So this section is added.
When it was added, 30.
My lord, yes, I am giving the date, my lord. We made the IO made the application, and order was 33.
When
24.
the petitioner was arrested?
My lord.
When the petitioner was arrested?
Arrested was 83. 83.
So when he was arrested, this section was not there.
Yes. At that time, it was not there.
So at that time, there was a requirement of 41A.
Yes, 41A is, yes, madam, with all respect, I submit, my learned friend knows, 41A is not an absolute bar. What the IO requires is to record reasons,
Yes.
reasons to believe.
Yes.
It is not an absolute bar, my lord.
Okay.
Now that has been done. I also in the case there, record the reason has been recorded by him. Now, my lord, I am coming to the submissions made by my learned friend. And Anas Kumar also does not say that 41A notice is my lord absolute bar. Now, my lord, I beg to draw your lordship's attention to page 15 of the petition, my lord, which is termed as, my lord, first FIR by the petitioner.
Page 15.
Page 15 of the petition, my lord.
Yes.
My lord, I may be permitted to take your lordship through the contents of this FIR. I am to inform that 10 numbers of NSA detainees from Punjab are presently lodged in Central Jail, Dibrugarh, as per detention order of the District Magistrate, Amritsar, Punjab. In this connection, I would further like to inform that the NSA detainees resisted a search operation which was to be conducted in the NSA detainees wards of this jail on 17 to 24 with the help of an anti-sabotage search team detailed by the Superintendent of Police Dibrugarh. However, the anti-sabotage team was able to execute the search operation after some time, and the following authorized materials, devices were recovered. Now, my lord, either this information should have been lost by anti-sabotage team or the Superintendent of Police Dibrugarh, because the anti-sabotage team was detailed by the Superintendent of Police Dibrugarh. And what he alleges that the detainees were, my lord, resisting the, my lord, search operation. That is his allegation. He alleges that the detainees were resisting the, my lord, anti-sabotage search team.
Okay.
Now, my lord, so far, my lord, this offense under section, under the, my lord, UAPA Act, this FIR is absolutely, my lord, cryptic information. This cannot be treated as a FIR, because using those electronic devices which were used by the, my lord, detainees, my lord,
No,
call
but
was
apart from detaining, there is a mention that SIM and mobile phone were also recovered.
from whom it was recovered, which detainee,
That has to be,
why search operation was made.
that has to be investigated.
Exactly, investigated. That is why I am saying it does not reveal the entire facts. On what basis, Superintendent of Dibrugarh, Superintendent of Police Dibrugarh detailed the anti-sabotage search team to carry out search operation in the jail? That is why I am submitting. But this is a cryptic information in respect of the entire facts and in respect of the offense being committed in the jail. Now, my lord, this seized using by this, my lord, electronic devices, call was given to Sikh community of Assam. Call was given to Sikh community of Assam to break through the jail and rescue them. My lord, I produce, my lord, all these things. These things are in the case there, my lord.
No, the law which I understand
My lord,
is that suppose an FIR has been lodged and investigation is initiated, during the course of investigation, something is revealed which is connected with the first FIR, then you can add the offenses if it is in the first FIR itself. If it is revealed that the the informant was himself an conspirator or the accused, you could have made him accused in the first FIR itself.
Yes.
Otherwise, later on, it is going to give you trouble during trial.
Yes. Well, I'm trying to answer this question. Now, first question arises, what is the purpose of lodging an ezahat? To set the investigating agency
That
into
was
motion.
that in this case, what happened? Let me understand.
Yes.
In this case, investigation was initiated. And during investigation also, only you came to know that present petitioner is also involved. He provided the mobile phone. This was revealed during the investigation of the first case, where the revelation was made that mobile was found from the possession of NSA detainees. So regarding commission of the offense, some information was given in the first FIR itself. Some additional facts came to your notice that some more people are involved, including the present petitioner. Because other facts remain same. Some additional information like these 6 communities, this you came to know only during investigation which was initiated on the basis of the first FIR. So therefore, he is submitting that that is not his ground for seeking bail. Bail has been sought for as in the first FIR was registered under section two sections were registered. And in second FIR also separate sections were added, which were for which the punishment was not more than 7 years when he was arrested. So therefore, requirement of notice under section 41A was necessary. That is his submission.
That is his submission. Yes. But in my understanding, with limited knowledge, my lord, so far Anesh Kumar case is concerned, my lord, that is not absolute bar. Even if it is, my lord, below 7 years punishment,
yes,
that is not absolute bar. If
by citing reasons,
yes, citing the reason is and then that has been done in the case there, my lord. I was noticed there, my lord, in the grounds of arrest, it has been stated. So that can, for that ground, my lord, with all respect, I submit, he is not entitled to bail.
Whether the case diary of the first FIR is there with you?
Is there no, that is not received. That is not called for, even I think.
That is not required.
No, my lord, I do not know, my lord, but perhaps that is not called for. I do not know, my lord. Today for the first time I have it. I would call for reason.
Mr. Bora, one query before he completes his answer. Apart from 41A, what is the other ground?
The second FIR does not lie at all in this context, my lord. It's because of the same thing. Because the first FIR, I have heard it from last 24 years, my lord. Always the other side, the FIR not is the encyclopedia of the events. That was the always goes by. And now they are saying that this is a cryptic FIR, my lord.
Yes, that is
a cryptic FIR, man. Let me complete, Mr. Das.
No, I have.
So that's why I'm saying this FIR is a complete FIR. What I said, my lord, very clearly, my lord, what else is required? I said initially they have registered those detainees, they have registered the search operation, then with the help of Superintendent of Police.
No, assuming it to be second FIR.
Yes, my lord.
And
I have been arrested.
How it helps you in getting.
Definitely, my lord, this when FIR is not maintainable in the eye of law, lordship knows it. So many cases, my lord. The second FIR. The second FIR, why they have not arrested me in the first FIR? And after 20 days, what precluded, my lord, from
No,
arresting me?
second FIR,
It is the same case, my lord. They have admittedly, they have seized the same material which I have seized with the help of superintendent of police. Now said that why not the superintendent has filed a case? They are in my custody. Can somebody dictate me who will?
my query is different. Query is assuming that second FIR does not lie.
Yes.
It would be treated as a statement under section
162.
162.
Yes, my lord.
Then you will be treated to be been arrested in the first case.
Yes.
Then why should you get bail? If
In the
there are-
first FIR, then they should have come out with the first case. That this is the case, he is the conspirator or he is supplying everything. There is no material to that effect, nor that he has filed a false case. That's what I'm saying. The second FIR does not say so. That I have intentionally filed a false case to camouflage the offense. It's not their case, nor the grounds of arrest. The grounds of arrest is simply that I may help the accused to flee away from the custody. In this, so that is my one of the contention, my lord.
Okay.
And the second contention is that why they have lost the second FIR and why they have subsequently added a new section in the second FIR. When I have already filed it, and I have argued that contention before the High Court that the 41A was not compliant. The moment they have seen that yes, this 41A was not complied with, as far as the spirit is concerned, immediately they have filed this second section, my lord, and they took the permission just to create a bar under 43D. And one day before the case diary is produced before this court. So why they have not registered the same FIR? If they so much they are aware of the second FIR, in the second FIR every details was executed, but why they have left out this particular section? And why not? So intentional to debar me to get the benefit under 41A, because they have admittedly said we have not followed the 41A. And I have said also, I am not asking for the compliance. The 41 is mandatory. I have never said so. I said that the ground cited by the police as well as the magistrate for not complying with the 41A, it's not up to the mark of the until and the honest Kumar. Apparently, my lord. So they just took and they came to know that yes, they have failed to comply with. So debar me from that ground.
Okay, let Mr.
That is my contention. So subsequent adding of the section, my lord, subsequent adding will not debar, create a bar of 41A. 41A will not remain, my lord. Subsequently adding, they may add hundreds of sections. But the intention is legislator at the 41A and the magistrate at the first instance for the remanding for the person in the custody. That will remain, my lord.
Yes.
And
Mr. Das.
8.3, what is the substantive offense, my lord? Nothing.
Regarding,
So,
no,
the-
what you said. was
The
not-
day of arrest, so that is the section, my lord.
Okay. Day of arrest is
13.8.3, my lord. Then the
8 of-
PC Act, 13.1.
Okay, let Mr. Das complete.
Now, my lord, so far, contention of the petition, that it is second affair, his affair is the first affair. My lord, contents are totally different. Does the affair lodged by him says that he in collision with some other persons has supplied the electronic devices to the detainees?
Why I should say?
Exactly. That is why it cannot be treated as first affair.
Oh.
Now, please don't comment like that. Being a senior advocate, you are
Yes,
expected
please
to
address.
maintain the decorum of the court.
I know how
No,
to maintain.
you do not know. That is why I'm sorry to remind you.
Yes.
In the midst of my argument, you have stood up.
No, court asked me question. That is why I stood up.
No, at that time, not asking.
Please maintain some decorum.
Don't teach me.
That is the unfortunate thing. That
If
is
you
the
continue,
unfortunate thing I
I'll-
happen to teach you.
If both of you are done with, please address me.
No, this is not.
Mr.
Why something like this?
Mr. Das.
This is not, I was not taunting you. How will you taunt me like this? I am 10 years senior at the bar
No, please
from you.
address.
I have also put in 35 years of practice in this court.
Mr. Das.
I'm sorry, my lord. Normally I don't react to such things.
No, I can also react to many things out in, but I'm not reacting also because he has stood up. But this is not the done.
No, please.
I know
don't react.
where,
No,
where,
let us-
where,
I'm
where
sorry,
everything
Milord.
is pinching,
I'm sorry,
I know
sorry.
everything.
Sorry for the interruption, my lord. I'm sorry, my lord.
You have to
No.
assist the court only.
My lord.
Please assist the court only.
My lord, I understand. No, my lord, when somebody taunts, my lord, it certainly hurts the my lord, person. Anyway, my lord, now the FIR lodged by the petitioner does not reveal the entire truth.
Okay.
That is why I am saying that this is, my lord, for all practical purposes, this cannot be treated as first FIR. First FIR in respect of the occurrence. Now, after, my lord, the search operation and after this FIR, when investigation proceeded, the truths came out. And the IO found that he is in collusion with some other persons. So that is why now we are presuming that, yes, let us for the time being presume that it is the 84, that 84 case, number 84 is the second
84.
FIR. Presuming for the first time, it is. My lord, how the prosecution will lodge? What will be the evidentiary value of this? Because this will be treated, that FIR will be treated only as an that will not be admissible in evidence, because that FIR was lost by him, and that FIR cannot be used against him, because this is a statement, that FIR is a statement before the police. First FIR, suppose prosecution is launched on the basis of first FIR, the FIR lost by him. That cannot be used in evidence against him, because that will be a bar, that FIR will be a statement before the police, which is not admissible in evidence. That is why, my lord, this FIR, subsequent FIR is a
First
signed.
FIR status is not like that.
My lord.
It is the status of the second FIR only, which is barred by 162.
No.
Now, we will not go into those aspects.
No, my lord. Exactly.
First
That is why.
FIR can be admissible as.
That is why first FIR, second FIR, all these things cannot be decided in a bail petition, my lord.
And that may be your submission. But
First FIR, second FIR, these issues cannot be. Right now, it is difficult to, my lord, arrive at a conclusion.
no, but
That FIR cannot be for any under any stretch of imagination, my lord. That FIR cannot be used against him in launching the prosecution, because that FIR is a statement before the police made by the accused himself. So that embargo will be there in launching the prosecution against him on the basis of the FIR lost by him.
we will not go into those aspects now.
My lord. So, my lord, I have, my lord, segment or relevant question, my lord. Your lordship may kindly please, and my lord, on that regarding, my lord, addition of that section, my lord, I beg to my lord, refer to one judgment, my lord, that is Gurvinder Singh, my lord, where, my lord, the apex court has said, my lord, so far, my lord, offense under section 4 and 6 under the UAPA Act, my lord, jail is the rule, bail is exception. So, my lord, I am submitting, my lord, the entire case diary. My lord, you also may kindly peruse it, my lord. I have flag marked the, my lord, relevant portions.
What is your reply to the submissions made by learned counsel that during the pendency of the bail application, when you came to know their plea, that 41A is, they have taken a plea that 41A is not followed. Thereafter, you added this section after on 30th of March. That
No,
is
no, so far 39, section 39 is concerned, my lord. After the investigation progressed,
on the basis of the
that
material.
materials on record.
Okay.
And so why 41A is not, my lord, followed, not resorted to, that reason has been recorded in the case there itself. That is there, my lord.
Okay, Mr.
Just one reply, madam. The,
My lord, that
first of
copy of
all,
the judgment is also there.
first of all, the first FIR, the contention raised, my lord, it is absolutely, my lord, incorrect, my lord. Because the first FIR, this is not a confession, my lord. Only if it is a confession, then only record of 25, 26 comes into play, my lord. The first FIR, this is not a confession, this is a statement. Statement, there is no bar. Only the confession is bar before the police officer under the Evidence Act. Then it is a bar. First FIR. But if it is a statement, this is not a confession. First FIR, I have not confessed that I did so, I have supplied. So first FIR, there is no bar at all. Am I clear, madam? So 25, rigor of 25, 26 of Evidence Act, it's not come because the section 25, 26 says the confession of an accused before a police, confession, not a statement. They should understand that, first of all. And the second is regarding the case diary, material in the case diary. The Lordship kindly see the order passed by the magistrate. He has only gone through the forwarding report. My understanding of the law is that the first point of time, the material submitted me is the forwarding report before the court. On the basis of the forwarding report, I can only argue regarding the compliance of 41A notice, madam. And the magistrate also has to go through the forwarding report only regarding the compliance and non-compliance and what are the grounds. The case diary, subsequently, there may be hundreds of material why they have 41 has not followed. But the first document for producing me before the trial court on the first day on my arrest, only the forwarding report. It does not reflect any grounds. They rather reflect that they have not followed the 41A notice, admittedly, and the ground they have taken that detainee may fled away with my help. So my arrest is mandatory. And the magistrate says that I am satisfied with the ground. He is not given his own reasoning why he is satisfied by going by this case diary or whatever the material. So the Supreme Court says, no, you have to give also your reasons and the ground for belief. That is the until says. So moment they have seen that these are not followed, neither by the prosecution nor by the magistrate concerned, so they have added this section to debar me. And now they are saying just to bypass the 41 first FIR, because the first FIR itself is an information given by me, the seizure has been given. What else is required to be a first FIR? Only to register an FIR, only the cognizable offense is required. Not more than that. Who files an FIR? That's not the issue. Only requirement is that the cognizable offense under 156 has been made out or not. Here, I said they have not allowed us to such operation. Then with the help of the superintendent of the district, we made the such operation subsequently, and then we have recovered those articles. Is not it sufficient to make out a cognizable offense, my lord? Name does not require who has done it. Now I am saying it. The FIR is not an encyclopedia of everything. But the only cognizable offense. They are in the cell, and this has been recovered from the detainees. And what is the argument? That I have not stated from whom it was seized. So it is cannot be treated as an FIR. FIR can be only one line if it is a cognizable offense, my lord. The Supreme Court has said in many times. It can be on online if the cognizable case has been made out. Then the investigation proceeds through. And then under the investigation, you can find material against me. There is no bar at all to arrest me. And that can be the first FIR itself is an FIR against me. It cannot be only used as a confession. That's the bar. Not the treating as an FIR. FIR is the first, only the confession is bar. That cannot be, they can rely the prosecution that in the FIR itself, you have confessed. That cannot be the ground. It cannot be treated as a confession because it is before it. But here it is not a confession also. It is just a statement of fact. So it is an FIR itself. So, and they are saying that these FIR, where is the need for me? And where is your need? In the second FIR, why you have not pointed out that the first FIR is a false, fabricated? Why in the forwarding report not you have pointed out?
That you have already said.
Yes, man. That's all, man.
Which is discussed in Antic.
This Lordship can 8.3, just mark it. I'm not reading it. 8.3 under paragraph 27 of the Ernest Kumar. These are the 8.2 and 8.3. These are the requirement of the absolute requirement. This is the mandatory provision, my lord.
Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr.
D.K. Boydno.
D.K. Boydno, Learned Counsel for the petitioner. Also heard Mr. D. Das, Learned Additional Public Prosecutor. Let this case be listed for delivery of orders on 10th of April, Wednesday.
Obliged.
I will require the case diary. Case diary.
Yes, yes, my lord, that is why I have handed over.
I'm sorry, my lord, for if any had caused any inconvenience. Obliged.
So today probably there will be no time.
So instead of taking your matter, I can take up other matters. Because it is unlikely that.
Yes, let's see.
Mr. Kyle will finish today.
And let's see, probably there is a function, High Court function. High Court function is also there.
We may have to.
Yes, go early.
Then
When can we take it?
On Monday,
Monday at 2, Lordship, not at 2:30, Lordship.
No, Monday too, because today I have to some my material fix. That's why I have asked your lordship to fix it today.
2 only?
On Monday,
Monday at 2, Lordship.
My lord, I was 20.
No, we'll continue up to 4:15.
Yes, lordship. On Monday we'll finish.
Today we are continuing up to 4:20.
4:20.
4:20, but we are not taking up your cases.
Lordship
Lordship is
Other
taking
cases.
other cases.
Our cases may be fixed on Monday at 2 p.m. Lordship.
Item number?
Lordship, there are 22, 46, 47 and item 52 to 60.
22.
Yes. 22, 24. 22, 4, 22, 24.
22, 24.
46, 47, 48. Then 52 to 60.
Yesterday he started in item number
52 to
53.
60.
53. 53.
To 60.
Item number 22, 24.
46, 47, 48.
46, 47, 48.
And a supplement list, lordship. 52 to 60 maybe.
Yes, supplementary.
52 to 60 lords.
50.
52 to 60.
52 is criminal.
53 to 60.
52 yes.
Hey, 52 belek admission.
53 to 60.
53 to 60. I'm sorry.
53 to 60 and argument started in item number 53, Lordship.
These matters could not be taken up today due to paucity of time. List these matters as partner matter on Monday at 2 p.m.
It will start from this bail application number 4136 2023.
Item number?
Item number 53.
Item number 53. First one.
May it please your lordship,
Item number 26 be listed again on this Tuesday lordship.
No, we are taking up matters now.
Lord, I think time constraint is there. Your lordship will take it. It's a part-heard matter. Lord.
Oh, this was long.
It will
It
take
will
some
take
time.
time.
It will, obviously, it will take some.
It will take some time.
Let it be on
When
Monday, lordship,
Monday, again, we have fixed already.
Monday,
We have already.
Tuesday then lordship.
Monday, my lord, I may not be here.
Learned friend will be in the address, so
When-
Tuesday lordship.
When can we fix it?
Tuesday করিল
Or
আরেকটা
after
matter
Bi-
আছে আপনার।
after Bihu?
The lordship may fix it on Tuesday.
After Bihu.
Tuesday, my lord, your lordship.
Okay. On request of learned counsel for both the parties, let this matter be listed again on
Tuesday.
9th of
Hmm?
April as part of matter.
Oh, bless you.
Lordship, on the last occasion, the up-to-date reports from the Honorable Insurance Session Judge was called for. I've submitted one certified copy of the deposition of witness, PW1.
This also involves same question. You are also on long incarceration.
Lordship.
Or any other ground is there. What is your ground for seeking bail? What are the grounds?
Lordship, on merit, Lordship, if Lordship peruse this statement that I have, this deposition of witness PW1, Lordship, the FIR is saying that the witness was very important. In front of the witness, the seizure was done. And if the statement in the witness, if the statement is taken into consideration, Lordship, it says something different. So Lordship, this is one ground. The second ground, Lordship, yes, I am behind the bars for more than 1 year, 8 months, 613 days, Lordship. And I'm a victim of circumstances. The investigation never went up to the exact person for whom I am behind the bars. So I humbly pray that I may be allowed to go on bail, Lordship.
My lord, in this case, Lordship, admittedly commercial quantity was recovered and seized from their position. And my lord, charges were framed on 21 to 2023, Lordship.
Five witnesses are there.
And trial has already commenced, Lordship. One PW had already examined. Now the next date is fixed on 26 for 2024, next date fixed, Lordship.
Lordship have observed that 26/3 was there, but due to holy holidays, evidence could not be taken up. So the next date has been fixed on 26th of April, Lordship.
40 kg ganja. What was recovered?
40 kgs ganja.
40 kg, 30 gram ganja road.
2 persons were apprehended. 3 persons were apprehended, but from the 2 persons, from their position, this ganja was recovered.
Okay. Anything else?
There is no any prolonged delay, Lordship, no incarceration, because Lordship, statute has given Lordship 360 to 360 days, Lordship, for the purpose of investigation, Lordship.
Mr. What is the name?
Dr. P.P. Mehdi, Lordship.
Dr. P.P. Mehdi, learned counsel for the petitioner. Also heard Mr. R.J. Boga, learned additional public prosecutor. let this case be listed for delivery of orders on 9th of April. 9th April.
9th April, Lordship. 9th May, Lordship. Or 9th April.
Already.
May it please your lordship. Lordship, this is a 439 bail application, lordship, 196 days in jail custody, lordship. Here FIR lordship will find on page 15, lordship. Page 15 is the FIR lordship. There is a love affair between this lordship victim and the
No, but scan copy of search that case, Lord. Scan copy also.
Lordship, no.
Victim has been examined.
No, Lord, the victim is yet to examine.
Lordship, as per section 35, Lordship, the victim evidence has to be recorded within 1 month after taking the cognizance of the case. That too, Lordship, they are.
Also is there.
POXO 6 is there, Lordship.
The notice were issued.
Lordship, track report is there, Lordship, track report, official note, Lordship, 7-3, Lordship.